Please be seated. Good morning, everyone. I welcome you all on behalf of Justice BP Jeevan Reddy Center for International Trade and Business Law to the second day of the two-day international conference on crisis and solution to WTO's dispute settlement system. So to kick off the second day of the conference, we'll start with the panel discussion on a very pertinent topic, demystifying the ongoing WTO crisis and the way forward. It is pertinent to understand the reasons behind the ongoing WTO crisis in order to resolve the deadlock. So one of the reasons people may cite for the current crisis is that this is a very first thing that most of the scholars do talk about is the blocking of the appointment and reappointment of appellate body members by the United States. And even the United States had raised some concerns, like the appellate body members repeatedly violating the mandatory 90-day deadline for issuing the report, or appellate body members deciding the cases after the terms have ended. This was a question that we did receive from the audience also yesterday, or the appellate body members issuing advisory opinions. So there were many other reasons that the US had raised. So to better explain the US concern and also to discuss the USA's Inflation Reduction Act, I would like to invite our first panelist, Professor Leela Chokron, who's a professor and director of the University of Portsmouth. Professor, the stage is yours.
Very good morning, everyone. So at the outset, let me thank the organizers of this wonderful conference, your VC, Professor Ra, I'm pleased to know for many years, and naturally, Dr. Kapil Sharma, Dr. Rosny Jha, she's here, and Elukia for this superb organization. It's a delight for me to see a new young generation of international economic law scholars, and I'm sure Nalsar will make a mark on the field. You have great space to become an important center for trade, investment, development, finance in India and in the region, alongside with many friends and colleagues from the WTO Center, CTLT, etc. So without further ado, my presentation is entitled Climate Justice at the WTO. So Kapil was a bit worried. Are you really going to talk about what I asked you to talk about? Yes, I will. And the whole idea is to demystify, as the panel title indicates, the whole tragedy, drama going on, unfolding for years at the WTO. So let's go on. Is there something like climate justice at the WTO? Well, you all know very well that climate justice, climate litigation is very much on the rise. Some of you might have seen this report, which is absolutely fascinating, and I invite you to read. And many of you have seen recently, a few days ago really, the European Court of Human Rights decision in the Swiss woman case, this elderly or senior woman who brought a case against Switzerland for violation of, or rather, I would say, inaction as far as climate change is concerned, arguing that climate, and we have seen a report 2 days ago in India as well, climate change has a greater impact on women's health, and they won't, interestingly. As of December 2022, we don't yet have the figures for this year, but you have nothing less than 2,180 climate-related cases in 65 jurisdictions. This is massive, this is increasing, and these cases are brought by a wide variety of people, from children, youth, women's groups, local communities, indigenous people, amongst others. So that's really interesting to follow. And why am I talking about that? Again, the climate case brought by this Swiss woman. They argue that, as I just said, that Switzerland violated their rights, and in particular their right to a safe, healthy environment. And at the same time, you had two cases which didn't really go through, one brought by France and the other one by Portugal. The court declared them inadmissible based on certain criteria. I'm not entering into the details, but just to remind you of the context. Climate justice is also very prevalent at the International Court of Justice. Extremely recently, 2 days ago, we have seen the International Court of Justice, which is very much making the headlines at the moment. That's really interesting for an institution which remained relatively dormant for years. International Court of Justice telling us that they've received nothing less than 91 written statements in the climate change opinion brought a few months ago by the United General Assembly of the United Nations. And these are advisory proceedings, as you understood. The United Nations General Assembly asked indeed the court the questions following. Do countries have an obligation to protect our climate for the well-being of people living today? What about the well-being of those not yet born? That is the well-being of future generations. So you see a great interest from all countries of the world, 91, nothing less than 91 written statements to the International Court of Justice for this particular case. And my last example, just to set the scene again, climate justice in Indian Supreme Court. You probably know better this case than I do. Really interesting case. Again, very recent, this bird case, which is very interesting because it sets the tone and it shows that, yes, climate is a human right, while the discourse generally on climate change is very scientific, very positivist, and not necessarily right-based. So there's a shift in the case very clearly, including in India. So now my transition. Environment is, of course, a human right. And why is it a human right? Because it has been recognized as such by the United Nations Council, Human Rights Councils, and the United Nations General Assembly. They have recognized the right to a clean, healthy, and sustainable environment as a human right. And we are seeing new claims centered around the violation of legislation related to net zero targets, environmental impact assessment, advertising standard and obligation under the Paris Agreement. Climate litigation at the moment is setting precedents for climate action all over the world, as we have seen in our several examples. And now, really, my transition, why am I talking about that? Precisely because China very recently brought this case, DS 623, and we could maybe, and I'm more than happy to discuss and start a sort of controversial discussion here, we could see that also as a form of reverse climate litigation. So this case you might probably have heard about, US certain tax credits under the under the Inflation Reduction Act, the implementation of the Inflation Reduction Act. What are the measures that issues? Actually, about a year and a half ago, in August 2022, the Inflation Reduction Act was signed into law by the American president, and it's known under the title of IRA, and it might well be the largest single subsidy measure in modern economic history, which encompasses a number of climate, environment-related provision. So the perspectives are very different from the perspective of the United States. The idea is the following. Trade is actually a sort of barrier. We have been, I'm quoting, we have been warning since before the passage of the Inflation Reduction Act that antiquated WTO rules would threaten our ability to realize the green transition. Prominent labor, environmental, and consumer goods have urged the US government to boldly implement the IRA and as intended despite trade pact attacks. So that's the perspective of the US, and they ask for climate peace codes. That's probably something you have heard about as well, to prioritize, according to their perspective again, climate action and a number of measures. And they say we must move forward with the IRA implementation and work to enact even bolder policies to transform our economy for a clean energy future and support other countries to do the same. Civil society plays a great part in this discussion and in this dispute. You have here a list of a number of civil society organizations in the US, but also in Europe, supporting this type of climate-friendly measures. You have more than 150 environmental organizations calling for climate peace clause, and more than 190 legislators from all states in the US calling for the same. So the impact of civil society, this is something we've seen in certain cases at the WTO, but not necessarily as clearly as we have seen recently in investment law. This is certainly extremely important, extremely strong, and has played a part in this very implementation of the Inflation Act and the reaction by China. But so, again, if we step back, what is this US Reduction Act? As you can see here, it's an act which proposes a series of measures supporting the American economy, and that's why it's called the Inflation Act, right? Because it was to sort of act again the inflation that we all know in our all different countries after COVID, and actually, as I said, just support the economy in providing a number of subsidies and different measures. Some of them indeed are climate related. Interestingly, what does China contest? The section 13401 of this act establishes the clean vehicle credit for qualifying electric vehicles. And how do you qualify? To qualify for the 3,750 battery component of the Clean Vehicle Credit Act, you need a certain percentage of the value of the battery components to be manufactured or assembled in North America. Here you go. So, okay, it's climate friendly, but to qualify, you have this localized North America component, and that's what China contests. Are we not talking about protectionism here in the name of climate change support, climate transition, and so on and so forth? And indeed, China has brought this complaint to the WTO and argues that a number of provisions of the WTO have been or are violated at the moment by this IRA and the precise provision for vehicles. In particular, you see the list here, Article 1 of the GATT, Article 3, Article 1, Paragraph 1, Article 3, Paragraph 4, Article 2 of the TRIMS, Article 2.2 as well of the TRIMS, the Article 3 of the SCM agreement, and again, that's mostly like that. So from a Chinese perspective, it's particularly logical, it makes sense, you are violating a number of provisions of the WTO treaty in implementing a protectionist measure. So that's really interesting, actually, to look at this dispute, which is at the very beginning of the dispute, the consultation phase. So let's just see, how it goes. They might simply drop the dispute after the consultation phase. But in any case, I think shifting the gaze and trying to analyze this new sort of disputes, and I'm be more than happy to discuss that with our colleagues, but trying to analyze this sort of disputes as climate litigation, as potentially trade justice, and I'll talk about trade justice later in the afternoon, is really interesting because it shows a different maybe role for the WTO dispute settlement and not necessarily something which is going to help you demystify or solve the problem we face at the dispute settlement body at the moment. But in any case, something which is growing, very much increasing internationally and deserves a great attention. That's all for now. Thank you very much, everyone.
Thank you, Professor, for bringing our attention to China's challenge to the U.S. Inflation Reduction Act. And it is not the first time that countries want to reform the DSU. At the time of adopting the DSU, it was agreed by the WTO members to conduct a full review of the dispute settlement system within 4 years from the entry into force of the agreement. As early as 1999 itself, in the Seattle ministerial meeting, the negotiation to review and reform the DSU took place. But the review did not yield any much results until the ministers agreed in Doha to improve and clarify the dispute settlement understanding. In Doha round negotiation, again, many extensions were taken to conclude the review, as the mandate of the negotiation involved a broad range of proposals, including the areas of mutually agreed solution, third party rights, confidential information, sequencing issue, post retaliation transparency, amicus curiae briefs, time frames, remand jurisdiction, panel composition, and all other broad range of issues. So we have our second panelist, Mr. Atul Kaushik, former Additional Secretary to the Government of India, to tell us the key takeaways from Doha round negotiations that will be relevant for the ongoing DSU reforms. Sir, may I invite you to share your views?
Thank you. Yes, thank you. And uh, I'm very happy that you have narrowed down the topic for me to what takeaways we can take from the Doha round negotiations about the last bullet of Professor Leela Shokroon's presentation on what is the role of dispute settlement on issues like environment, climate justice, labor, and so on. Uh, there are two aspects to this theme that you have suggested on takeaways from the Doha round, or the DDA, Doha Development Agenda, as it was called. One is the implication of the DDA negotiations on DSU specific reform work. So, what are the endeavors that have happened relating to reforms within the DSU? And the second is the implications of the larger state of play of the DDA in general on the DSU reforms. So let me take the first one first. We yesterday we were talking about formalization of DSU reform work program, and we talked about the fact that some of the issues required clarification even at the time of the acceptance of the dispute settlement understanding during the Uruguay round. The anti-dumping provision relating to permissive interpretations, and then some other decisions. For example, we needed some specialist panelists for the services agreement, which the membership of the GATT felt were not available on their indicative lists, and therefore there was a special decision of the ministers that we should look for specialists in the services negotiation to put on the indicative list. But the larger review that was mandated by the ministers, also we mentioned yesterday, which was a full review of the dispute settlement rules and procedures within 4 years, that is by 1998, and to decide whether to terminate the DSU and go back to the GATT days dispute settlement, or to modify or continue it. Now, as we discussed yesterday, it started very late. It started in the year that it was supposed to end. Um, Although there were extensive information in exchange and discussions, it was obvious that there's not going to be a decision, a consensus decision. So it was extended to the next ministerial. The next ministerial failed, and after the Seattle ministerial in 1999, there was a bit of a vacuum on what to do with the DSU reforms. And then came the Doha Development Agenda. Now, the Doha Development Agenda was uh, having a very specific negotiating mandate. So it kind of graduated the discussions on whether to continue, modify, or clarify, or terminate DSU to a negotiating mandate. So if we read the text of that paragraph of the Doha decision, we see how the process of formalization of the negotiating mandates happens in the WTO. Uh, Let me read out that text. It says, "We agree," and these are the ministers speaking, the trade ministers. "We agree to negotiations on improvements and clarifications of the dispute settlement understanding." So that is a clear mandate to launch negotiations, not just a review. Because by that time there was sufficient material on the table to require certain changes or clarifications in the existing understanding. And then it goes on to say the negotiation should be based on the work done thus far, which means the everything that has happened during the DSU review is carried forward to these negotiations, as well as any additional proposals by members. So this is the inclusive nature of negotiations that have been the hallmark of international governmental organizations like the WTO, which have a dispute settlement system that bites, and also is the crown jewel, as it was said yesterday, of the World Trade Organization. So the negotiations should be based on the work done thus far, as well as any additional proposals by members, and aim to agree on improvements and clarifications not later than May 2003. So we were in December 2001 when DDA was agreed, and less than 2 years were considered sufficient by the ministers to aim to agree on the changes to the DSU. At which time we, that is the ministers, will take steps to ensure that the results enter into force as soon as possible thereafter. So there was a reason behind this last phrase, in spite of the fact that the Marrakesh Agreement, the World Trade Organization was supposed to end the era of rounds of negotiations and to have to provide the membership a continuous forum for improvements, clarifications, negotiations through the various committees and councils that were constituted as a part of this new legal entity called the WTO. Uh, and The Uruguay round in particular, but also the previous rounds, were negotiated on this principle of single undertaking, which means that nothing is agreed until everything is agreed, while various rooms are negotiating various aspects of trade liberalization. So therefore, there was a distinction made from this single undertaking by the ministers during the Doha development agenda that DSU reforms is not going to be a part of this single undertaking. It is on a separate track. Why? Because the review mandate had already lapsed 3 years back, so the ministers felt that not enough work is being done by their officials, and was a view that the dispute settlement mechanism, the jewel in the crown, was too important a part of the World Trade Organization to be a component of the negotiated balance that we find in the rest of the negotiations or the single undertaking concept. So further trade liberalization can happen over time, but whatever commitments we have already, whatever obligations we have already taken as members need to be protected, and the economic operators of our respective membership require that security and predictability of the market access and other obligations that have been taken by members. Now, this was the context in which the DDA negotiations started. It was created, there was a special session of the dispute settlement body that was created as the negotiating forum for the dispute settlement understanding, and it engaged in several discussions. So from 2001 to 2003, a lot of discussions happened, a lot of proposals came. In fact, so many proposals came that the secretariat was overburdened with trying to get a hang of every proposal and put them into slots so that there can be a coherence in the topicality of each negotiating area. And this challenge continued for a long time. But alongside, there were other things happening in the other rooms of negotiations, which were a part of the larger single undertaking of negotiations for further trade liberalization, where things were not as progressing as well as in the case of some of the proposals that could have met a consensus by the membership on the DSU reforms. Uh, so there were several individual proposals, but also several joint proposals. And importantly, there were joint proposals that did not demonstrate the classic developed country, developing country divide. Because dispute settlement was such an important element of the statute book, uh, both the developed and the developing countries felt it is important to have a, a comprehensive review which takes care of those who have a right to secure their rights and to force other members to implement their obligations through the dispute settlement mechanism. One such group that India was also part of was called the G7 group, and it had, interestingly, three developed countries: Canada, Norway, and New Zealand, and four developing countries: Brazil, uh, India, Mexico, and Argentina. And the reason why these people came together was that during that short period from 1995, when the WTO came into force, and 2001, when the Doha Development Agenda was launched, they had already experienced the functioning of the procedures embedded in the DSU, and therefore they had something to say about it from a personal or a national practical experience of implementing the provisions of the DSU. So these concrete proposals had several issues. Professor Eklias mentioned, for example, that some of the issues that required review were remand, third-party rights, sequencing. So let me tell you that this G7 had already arrived at very good textual suggestions or textual proposals on all these proposals. So there was a separate, proposal on third-party rights. There was a proposal which contained provisions regarding sequencing and remand. And this was a proposal which was not only discussed within the G7 because they had to sign on the document that was submitted to the DSB special session, but also discussed across the board with other countries, but more at an informal level. And when these G7 countries felt that there was a emerging consensus or a critical mass of acceptance to the clarifications that DSU requires, then they used to submit the proposal to the special session. Now, this also shows the various formats in which negotiations go on. So there is a formal proposal of modality of submitting proposals, but there are also these informal conversations that keep on happening amongst delegations bilaterally and in coffee shops and lunch rooms, etc. Now, in spite of the fact that several of the proposals had reached what we call in WTO jargon as an emerging consensus, the fact is that unlike other uh, agreements in the WTO, a decision to make any amendments to the DSU requires an explicit consensus. Although explicit consensus has been in vogue as a practice, the statute does provide for majority decisions. But for DSU, that majority decision does not apply. The second reason was that by the time the members reached the Hong Kong ministerial, there were other issues that had come to the fore in the larger single undertaking. And those issues kind of overwhelmed what was happening in the DSU, despite the fact that there was a clear mandate from the ministers that these negotiations are outside the single undertaking. Now, after this slowdown beyond the Hong Kong ministerial in the rest of the negotiations, the dispute settlement special session chairs tried to bring the delegates together uh, to continue the efforts to get DSU reforms going, and they divided the work into 12 different proposals or areas on which negotiations are to be done. From 2011 or so to 2016-17, these 12 areas saw considerable progress. In the sense that the proposals submitted by several members uh, evinced the possibility of a common ground. However, the fact is that because of the larger DSU, outside the DSU issues like agriculture reforms, like issues relating to services not future services negotiations not progressing, I mean, the WTO membership felt that unless they get some progress there, why should they already give up their positions that they have agreed to or taken in the DSU reforms, even though it is outside the single undertaking? Now, this brings me to the second aspect of what are the implications of the larger DDA negotiations on the DSU reforms. We must remember that DDA came into being after two attempts to launch a round. In the previous two of the three previous ministerial councils, Singapore, there were these so-called Singapore issues on which negotiations were supposed to be launched, did not happen. Seattle was a failure. Uh, so although there was a desire, there was not enough of a political push for the round to be launched. DD8 came, or the Doha round came, in a very specific geopolitical constellation when there was the 9/11 attack in the US, and that led the Committee of Nations, the global community, to believe that we must show strength of working together to fight several issues in the world which are handled by other global organizations, but also in the WTO. And therefore, there was an intense desire to launch a round. So, in that context, the developing countries got an opportunity to infuse the text of the uh, decision of the ministers to launch the round with several issues of importance to the developing countries. And as a consequence, it was called a development round or the Doha Development Agenda. So, these development issues actually may not have entered the text of such a round but for the specific geopolitical situation in which the Doha round was launched. But after 2011, when Osama bin Laden was captured and eliminated, the world was going back to normalcy. Uh, the delegations realized that there's too much development in it and too little trade reforms in the sense of further trade liberalization that several of the key players in the WTO negotiations felt was necessary for the round to succeed. Now, the lack of consensus on these bigger issues, on the one side, further trade reform in terms of getting more market access into developing countries or deeper market access into developing countries, service sector, remaining issues on service sectors that I mentioned, and service modes of providing services, uh, agriculture, further industrial liberalization through deeper market access, particularly of developing countries. These issues, overwhelmed the rest of the so-called development element of the DDA, and therefore the actual discussions in the negotiating rooms did not match, or they were skewed away from the perception that one would get by reading what was aimed by the ministers to be achieved. And you see also that there was an attempt to lower the expectations about a successful Doha round. As I mentioned yesterday, by 2015, US was starting talking about the Doha round being dead, and the press by 2017 had actually declared it dead. And the formal position, of course, on record still remains that DDA is existing. It is not alive and kicking, but it exists. However, when you see the reports of the chairman or of the committees and councils and those who kind of give a sense of the house to the membership, you find that the Doha round or the elements of the Doha round receded in importance in terms of what they were telling the membership in their respective committees and councils. Take the example of the Walker process in the DSU reforms. So David Walker did an excellent job of coming up with some of the solutions to the apprehensions of the US on the so-called overreach, judicial overreach of the appellate body, and therefore those solutions were presented by him as a good case for negotiating a consensus. But that presentation by David Walker did not even mention DDA. So these are some of the indications that we had that now DSU reforms have become a part of the larger gamut of issues, and therefore, unless you make progress in the other issues, you are not likely to get a solution. This is besides the fact that, of course, US had some great problems, great issues. We can talk about that later. But also that uh, the Doha round was considered too stale by that time. 20 years had passed from the time that Uruguay round implementation could see trade liberalization happening both in developed and developing countries, and trade growth as a consequence, economic welfare elements were demonstrated. And then came the issues that Professor Leela Shiproon talked about, for example, issues relating to climate justice, environment, labor standards. These were issues that were brought even in the first ministerial conference in Singapore, but not with the resolve to get them onto the negotiating agenda. But now there is a resolve, and that is why if all the members are not agreeing for a mandate to negotiate these issues, there are plurilaterals happening outside of the formal negotiating processes defined in the statute through joint statement initiatives, so on and so forth. So we are in a real melting pot here now in the WTO, where the poor DSU reform, which was supposed to happen independently of what is happening in the rest of the rooms in the William Rappard building, is left asunder. And the other issues are being discussed, not negotiated or negotiated, or informally or formally discussed in groups or discussed by champions in so many formats that it's very difficult to make a sense of which of those formats should now graduate to what we can actually call a launch of a negotiation on these issues. So this is where I end on what are the implications of DDA and also the larger state of play of the Doha round on the DSU reforms. Thank you.
Thank you, sir. Thank you for very briefly explaining the context surrounding Doha Development Agenda and the implications of the same on ongoing DSU negotiations. Next, as Indians I'm sure that all of us wonder about India's standpoint with regard to the ongoing crisis, and who better to give us the Indian position in the ongoing DSU reform than Mr. Jayant Das Gupta, former ambassador of India to World Trade Organization. Mr. Jayant Das Gupta has been working as secretary to Economic Advisory Council to the Prime Minister since January 2007. He has dealt with the Doha round negotiations at the WTO between 2006 and 2008 in his capacity as Joint Secretary in the Department of Commerce. Earlier in the 90s, he was the Director of Exports in the Ministry of Textiles, and again, he there dealt with Uruguay round issues. Mr. Dasgupta belongs to the Bihar cadre of the IAS and has handled a wide range of assignments within the state government. And he also worked as the director in the Trade Policy Division in Commerce Ministry, and he had contributed substantially in India's negotiating position on issues related to anti-dumping, subsidies, and most of its disputes as well. He participated directly in several multilateral and bilateral trade negotiation, including the anti-dumping and subsidy negotiation under the Doha round at the World Trade Organization, as well as at OECD steel subsidies negotiation. So, and also his contribution with regard to India's submissions in various landmark WTO cases is also very significant. So, with this, let me welcome Mr. Jayant Dasgupta to share his views about India's standpoint. So, the floor is yours.
Good morning, friends. It's a great pleasure to be amongst you here. And I am really privileged to have been invited by Nalsar. And uh, I wanted to thank the Honorable Vice Chancellor, the Registrar, Ms. Vidyulata Reddy, and of course, above all, Professor Kapil Sharma, and the Center for WTO Studies to have invited me to this conference. I will very briefly touch upon India's strategic interests in the DSU reforms. But before that, I would just like to give a bit of a background as to how the DSU evolved. Since the GATT days, I think the topic has been covered at great length yesterday by one of the panelists. But I would just like to draw your attention to some of the important points relating to the evolution of the system and why the DSU was negotiated in the Uruguay round, and it came into effect from the 1st of January 1995. So in the early days, 1948, 1st of January, the GATT 1947 came into effect. The two articles of GATT 1947, which also form part of the WTO agreements, they form this agreement of GATT 1947 forms the cornerstone of GATT of the GATT WTO legal framework. Now, Article 22 and 23, they spoke of, there was no dispute settlement in the GATT system. Article 22 and 23 provided for a consultation mechanism, and in case there was a dispute, how it could possibly be resolved. But it was built upon over a period of time, and so that is how uh, it came to a certain level of maturity by the 1980s. In the initial years, the consultation requests under Article 22 were often delivered verbally between one delegate and another. And if you look at the old GATT history, 75% of the GATT cases related to just the 5 countries, major countries, the US, the European Economic Communities, as it came to be known subsequently, because earlier there were individual countries, European countries, West European countries, which were GATT members. Canada was another one, and Australia was the fourth one. So these were the 4 or 5 countries which accounted for 75% of the cases. And it was done in a manner which was a gentleman's club kind of a thing, that disputes would get raised, they would get sometimes resolved amicably, sometimes they would be referred to the contracting parties, which meant the council, general council of the GATT as a whole. Now, it evolved from there because countries realized that it was too cumbersome a process for the General Council. It comprised, I think, about 23 countries in the beginning of GATT, and it expanded from then on to resolve disputes, to hear very carefully the arguments put forward by the two parties, the complainant and the respondent, and then give a kind of a reasoned ruling. So the panel system evolved over time. And by the 1970s, the panel system had come into being in a more or less permanent manner. Now, apart from the agreements, the Tokyo round led to certain understandings and a code, certain codes. Now, these codes also built into them, the anti-dumping code, the countervailing and subsidies code, etc. They built into themselves a dispute settlement mechanism. So after the Tokyo round, there were panels which were set up under these codes as well. Now, there is a problem which was faced in terms of jurisprudence, because when you have agreements, you have panels ruling on them, looking at various legal issues, you would like to see what had a panel decided on a particular matter or a subject earlier. It is not necessary that it should have a binding value, but it could definitely have a precedential value. Now, the WTO Secretariat, after a great deal of research, has come up with a list of about 316 cases, and it has said that these are not exhaustive cases. In fact, in the course of this report, it was found out that India had filed a case against Japan in 1980, for which no records are maintained in the GATT WTO Secretariat, but there was a cross-reference to this case in another matter, and that is how they stumbled upon this matter, that India actually had filed a case. India had filed 7 other cases during the GATT era. Now, a very interesting point emerges that out of the 316 consultation requests were issued, 157 panels were established as a consequence of these 316 requests for consultations. Many of the requests for consultations, of course, did not get resolved, but were dropped. One of the things which has to be mentioned is the asymmetry of power, which used to play a very big role in deciding the fate of requests for consultations, as well as the action taken by a potential respondent, and even at the end of the GATT panel process. So out of 136 reports which were issued by these panels, 157 panels, only 96 of them were adopted. 40 were unadopted, which meant that they did not receive consensus. Mainly the respondents who were at the receiving end and had to comply with certain measures to be either withdrawn or modified in the light of the GATT panel rulings, they blocked, they vetoed the adoption of the report by GATT. Everything had to be done by consensus, and even one member, if it were powerful enough, could block consensus. So if you look at, again, the respondents who were largely responsible for the unadopted reports, the European economic communities and the US were the two major culprits in this regard. 51% of the cases which were filed in the GATT days from 1948 to 1994 were filed between 1986 and 1994, the last 10 years of the GATT, which meant that with increasing trade volumes, with countries becoming more protective about their rights and sensitive about their upholding their own rights, would take the other side to court. So this just goes to show that there was a greater emphasis than in the earlier days of resolving disputes, let's say over a cup of coffee or a round of golf. It had become much more judicialized and legalized in that sense. Another very interesting fact is that between 90 and 94, when the GATT era ended, only 11 out of 27, which is less than 50% of the GATT panel reports, were adopted, which means there was a great deal of dragging and kicking by the respondents, mainly as I have mentioned, the two major traders, to accept the verdict of the panels. And 10 of these unresolved cases of the GATT era, they again reared up their head in the WTO, and fresh cases were filed under the new DSU. Now, this provides the backdrop against which, in the Uruguay round, the DSU was negotiated. And this will have a bearing on the issue of India's strategic interest in the DSU. The first thing is, as I have outlined, there was a great deal of unpredictability and uncertainty about how a panel proceeding or a panel report would be treated, how the respondent would or would not comply with a GATT panel's findings. So if one of your rights guaranteed under the GATT 1947 had been nullified or impaired, you had no certainty that an impartial panel would first rule in your favor, and second, that it would get adopted, and third, that there would be compliance by the respondent party. Would you like to be, as a lawyer, as a budding lawyer, be put in the same position if you were litigating on behalf of a client when you didn't know that even if you succeeded in getting a verdict in favor of your client, there would be no compliance? There would be no execution of the decree as in civil suits. It could be blocked. So that is why when you are dealing in trillions of dollars, the latest figure available for 2022 of world trade is $31 trillion of goods and services traded on the international arena. Now, when you are dealing in such huge figures with billions of people's livelihoods, earnings, lives involved in international trade, you would like to have a regime where there is predictability and uncertainty is removed. And to provide that, you have traveled a long distance from the Smoot-Hawley Act of the 1930s of the US, which led to the transatlantic tariff war, which in turn led to the establishment of the Bretton Woods institutions and, of course, the formulation of the setting up of an international trade organization, which couldn't be set up because of US intransigence and shooting it down. And it led to ultimately the setting up of GATT in 1947. So the first and foremost issue is about predictability and certainty. The second is, if you want to remove unpredictability and uncertainty, you have to dispense with, completely shun, prohibit muscular unilateralism, the kind of thing which we saw during President Trump's the first tenure, when we had duties imposed unilaterally on iron and steel and aluminum imports into the US from 7 countries or groups of countries, including India, just unilaterally, because it was against national security. Apparently, American tanks were being made of iron and steel, which was coming from foreign countries. That was one of the things jocularly mentioned. It's a fact that more than 80% of the steel getting into the United States comes from other countries. But that apart, this is the kind of thing which could still prevail if the appellate body is non-functional. Because there is no appeal, there is no compliance panel which follows an appellate body report or ruling after it is adopted by the membership. And there is no retaliation. So you can carry on if you are a large trader and you're not even bothered about retaliation. You can carry on like, if I may put it slightly harshly, like a bull in a china shop. So that is why this 2-tier system was thought about, that if the panel of 3 members who could err in certain respects in coming to their findings on a particular subject matter, if they made an error, it could be rectified by a higher body comprising much more experienced and people of eminence who were to be nominated to the appellate body. And very interestingly, you'll find in the negotiating history of the Uruguay round, the US was one of the major proponents of the 2-tier system, including the appellate body. Little did it foresee the fact that later on it would be very much against the present form of the AB, which is a creature of the DSU, which the US helped to create. Now, India's core interests are both defensive and offensive interests. I may explain to those of you who are not very familiar with this offensive and defensive interest in negotiations, this terminology. Defensive interest means that you want to protect something which you have already got, which you want to preserve and conserve. And offensive interest is something which you don't have, but which you have an aspiration or an objective to achieve. So India's defensive interest, mind you, I wanted to also mention the fact that before the liberalization of 1991, India's footprints on the international trade arena were very few and far between. India's exports, if you look at the figures, mainly represented textiles and clothing and a few other items. But now it has expanded very widely to go up to $451 billion in goods and more than $300 billion in services. India now occupies or has a share of more than 3.5% of international trade. It's another matter. International trade means both imports and exports put together. Now, China, of course, is way ahead. Its exports itself are about 16% of global exports. So we are way, way behind. But the fact is that India's exports, its aspirational goals, let's say, of Vikasit Bharat, cannot be achieved till India becomes a major exporting country. Whether it exports the kind of manufactured goods that China has gained mastery over, or it gets into high-tech exports, or it focuses on knowledge-based industries, services exports. The fact remains, if we want to achieve our aspiration, we will have to export much more than what we are doing today as a percentage of our GDP. So, the stake that we have in the dispute settlement system is going to increase only with the passage of time. I was just reading the figures. If you look at the WTO, the Americans have, in the WTO, there have been 623 disputes till date, if I'm not wrong. The last one was filed by China against the Inflation Reduction Act of the US. I think that is the last one. The US accounts for 159 cases in which it is the respondent, which means that in 25% of the cases, the US is the respondent. So other countries have complained against the US in the WTO dispute settlement system. Against the European Union, 94 cases have been filed, which means 15%. So between the two of them, they account for 40% of the total WTO dispute cases which have been filed since 1995. As far as their complaints are concerned, the US has filed 124 and the EU another 110. Interestingly, China and India, China became a member only in November 2001 at Doha. India has been a founding member of the GATT and has continued. So it was a founding member of the WTO also in that sense. Both of them have filed 24 complaints apiece, which is about 3.8% of the total complaints filed in the WTO era. And China legitimately has been at the receiving end as a respondent, 49 cases, and India in 32 cases. So the short point is that with the passage of time, with their growing export performances, India and China both are going to be major litigants in the WTO in future if the WTO continues with the appellate body in place. Another point which I wanted to mention, and that India has an exemplary record in complying with panel and AB rulings. Whereas, if you look at the largest number of non-compliance issues, they all relate to the US. Starting with, of course, the zeroing matter, because in the first 10 out of the 11 cases, the US had lost in zeroing, and it just refused to change its domestic legislation. Now, the formalization of a compliance panel and retaliation rights, including the right to cross-sectoral retaliation, is an embellishment on the WTO. It further strengthens the strong foundations on which it is laid. And this is my last slide. Thank you. What is the alternative to a two-tier system? Go back to the GATT days, have a free-for-all, might is right, or this MPIA, which the European Union has put forward, this has many flaws, and I don't want to discuss it because it would be, not outside the ambit of today's discussion. But if it were to gain a lot of support from the rest of the membership, the AB is not going to come back ever again. This would be the default mode of appeals. And that would be choosing a second best or third best, or a very poor substitute as an option. But having said all that, India supports the US stand on 3 of the issues: that the appellate body should not create new law or indulge in judicial overreach. Of course, it is subject to interpretation by each country depending on the case which is being discussed, whether there was judicial overreach or not. If it is at the receiving end, each country thinks that the appellate body has indulged in judicial overreach. And if it gets a favorable verdict, then it feels that it's all right. But the other party, which has lost, does not quite believe so. The AB report should definitely have persuasive value, because otherwise this body of jurisprudence will never get maturity, never attain maturity. And 2, you will end up reinventing the wheel and coming up with different conclusions based on more or less similar facts, which is going to be the bane of the judicial system of the WTO. So that has to be avoided. And last but not the least, the appellate body members now have 2 tenures of 4 years each. But I was reminded of a case during my tenure as ambassador, when the US refused to extend the tenure of a sitting member of the appellate body unless that member came to the US embassy and spelt out, possibly in writing, that it would not indulge in new law, creating new law, and various other things, and that written communication would be transmitted to the higher authorities in Washington, D.C. Now, that was just unacceptable. We keep talking about the independence of the judiciary all the time. Once you have given a consensus decision to choose an appellate body member, then you should not be in a position to question it and then, have this carrot and stick policy for extension of the tenure. That is why India, way back in the 90s, had asked for a 6-year fixed tenure for appellate body members. I met the doyen of Indian diplomacy at the WTO, Ambassador S. Narayanan, yesterday. He was our longest serving ambassador to the WTO for 7 years. During its most creative and, if I may say, tumultuous phase between 1994 and 2001, he mentioned in passing that he had had a similar experience with the US even in the 90s when he was ambassador, about extending the tenure of an appellate body member. So I will stop here. Thank you very much for your patience.
Thank you, Dr. Jayant Dasgupta, for briefly summarizing India's strategic interest and also for explaining India's defensive interest as well as India's offensive interest. Our next panelist will join us virtually. It is important that the rights and interests of the developing countries and LDC countries are also protected. And therefore, for the theme of this conference, it is very important for us to examine the implications of ongoing DSU reforms on special and differential treatment. We have Professor Abhijit Das to share this observation with us. Professor Abhijit Das combines an extensive experience of international trade negotiation with formulating and implementing and managing trade related capacity building projects. He was the former head of the Center for WTO Studies, and before joining Center for WTO Studies, he had worked in UNCTAD India program during 2005 to 2010 with progressively increasing responsibilities. Professor Abhijit Das, most of you may know that he's also considered as a champion, academic champion of developing countries as well. So, who better than Professor Das to speak, to give his views on the implications of ongoing reforms for S&DT, the provisions for developing and LDC countries? So, the stage is yours.
Thank you, Alekia. I hope I'm audible.
So, we can hear you.
Thank you. So, at the outset, I'm extremely grateful to Justice Jeevan Reddy Center for International Trade and Business, Nalsar University of Law and Center for WTO Studies. In particular, I'm thankful to Professor P.S. Rao and Professor Kapil Sharma for inviting me to share some thoughts on reform and implications of the ongoing discussions, negotiations, particularly from the perspective of special and differential treatment. We need to bear in mind that, with the exception of a handful of developing countries such as Argentina, Brazil, China, and India, most developing countries have not been primary users of dispute settlement mechanism, not because they do not feel a problem in how at times their rights may have been infringed, but mainly because many developing countries find the dispute settlement mechanism too cumbersome and too costly to access. So it's very important to see how interests of developing countries in the dispute settlement process can be protected, can be furthered, but that is a second stage. The first stage, which is relevant at this juncture, is how the interests of developing countries need to be protected during the current discussions, negotiations, which are happening among a handful of countries. In yesterday's session, we heard a lot of discussion about the Marco Molina process and the text which has been produced as a consequence of that process. We need to remind ourselves that most of the developing countries who participated in that process were substantially disadvantaged. Let's also remind ourselves that the process, although characterized as an informal process, was actually a US led process, with the chair being literally foisted on the countries by the United States, which showed extreme reluctance to engage if its choice of the informal chair was not agreed to. And as the process proceeded, reservations, murmuring from the developing countries who managed to participate in the process could be heard. And some of the problems which the developing countries faced, these problems, I understand from some of the delegates, used to get mentioned to the chair of the informal process, but without any remedy. In fact, I understand from one of the documents shared by a kind delegate from a developing countries that a formal document exists. And I'm going to be quoting from that document. I'm leaking no state secret of any developing country. What that document says is, I quote over here, "We note that concerns and reservations that have been raised by us in the course of the ongoing discussions have not been recorded. The consolidated draft text that is now taking shape represents a misleading view and suggests that there is convergence on the majority of the issues in the text. Quotes closed. At another point in that document, the developing countries, or a handful of them, have said the following, and I quote them here: "We reiterate the call for the immediate initiation of formal discussions on dispute settlement reform in fulfillment of the ministerial mandate under MC12." Quotes closed. Why I'm saying, why I have mentioned this is that we tend to forget that not only does the eventual outcome need to be balanced from the perspective of developing countries, the process through which the eventual outcome is arrived at, that must lend itself to transparency, that must lend itself to inclusivity, and that must recognize that developing countries are often capacity constrained. They do not have the financial resources, they do not have the human resources to participate in an informal process such as the one led by Marco Molina. One final observation on the Marco Molina process before I move on to special and differential treatment issues. I mentioned that Marco Molina process really challenged the developing country delegates who were based in Geneva to participate effectively in this process. However, an exception was made to allow delegates to participate remotely online, and this exception was not made for any developing country. This exception was made for a developed country member. So clearly, the Marco Molina process left much to be desired from the perspective of developing countries. Let's come to the issue of accessibility. As I mentioned earlier, very few developing countries have been active in the dispute settlement process. Most developing countries lack full understanding of their rights and obligations as WTO members, as well as the opportunities that WTO offers to them. In a nutshell, developing countries need to build their capacities and have resources necessary to access the dispute settlement mechanism if they perceive that benefits accruing to them under the WTO's covered agreements may be getting impaired by measures taken by another member. So, in this context, I have 3 or 4 suggestions which could be taken on board during the ongoing and future discussions. Some of these suggestions are already on the table, but just to remind ourselves that these suggestions are relevant. First and foremost, enhance the provision of capacity building and legal advice and assistance to developing countries and LDCs by the WTO Secretariat in pursuance of very specific articles, namely Article 27.2 and 27.3 of the DSU. Second, could we discuss establishment of a dispute settlement fund within the WTO to facilitate equal participation and effective utilization of the dispute settlement procedures by developing countries and LDCs? Third, one of the ways in which some developing countries seek to get a better understanding of the DSU is by participating as third parties, but this requires them to demonstrate a substantial interest in the matter before a panel. Could this requirement be done away with in respect of developing countries who might want to participate as third parties in dispute? And fourth, is it possible to develop a mechanism to fund the cost of litigation through legal experts of the choice of developing countries, On this issue, very specific proposals were put on the table, including by my friend Atul Kaushik when he was negotiating so strongly and effectively on behalf of India at the WTO. Coming to some special and differential treatment provisions that could be contemplated in consultations, panel, and appellate body procedures, let's remind ourselves that DSU does contain S&D provisions. However, there is a need to make them meaningful and implementable in a concrete, operational, and accountable manner. Best endeavor clauses, which are currently in the DSU, are unable to demonstrate compliance by the developed countries or even by the in the entire dispute settlement process. Now, what could be some suggestions here? First suggestion is that if the country complained against is a developing country, could the period of consultation be extended for giving an opportunity to resolve the matter satisfactorily? Second, when the developing country complained against loses a dispute, could it benefit from a pre-specified minimum reasonable period of time? And linked with that is that when a complaining developing country prevails over a developed country, would it be possible to have a pre-specified maximum reasonable period of time for the developed country to bring its defaulting measure in conformity with WTO obligations? Let me come to the compliance stage, carry on with what I have said earlier, and just discuss one very important aspect, which is the weak footing on which many developing countries find themselves when, despite being on the winning side of a dispute, they are unable to induce compliance by the defaulting by the responding developed countries. How can developing countries attempt to induce compliance by developed countries? All of us are aware that bringing the defaulting measure into conformity is the best option. But let's also remind ourselves that the possibility of temporary concessions as well as suspending concessions or other obligations does exist. In accordance with Article 22.3 of the DSU, when it comes to retaliation, the general principle is that the complaining country should first seek to suspend concessions or other obligations with respect to the same sector as that in which the panel or the appellate body had found a violation, or if it is not practicable or effective to suspend concessions in the same sector, the prevailing country may seek to suspend concessions or obligations in other sectors but under the same agreement. If the prevailing country does not find it practicable or effective to suspend concessions or other obligations under the same agreement, then it has to demonstrate that the circumstances are serious enough so that it may seek to suspend concessions or other obligations under another covered agreement. Now, this is commonly referred to as cross retaliation in the WTO parlance. During the DSU reform process, India and a few other countries had made a proposal that when a prevailing country happens to be a developing country and the defaulting country is a developed country, then the right for engaging in cross sectoral, cross retaliation must be made available without having to go through the hierarchy which has been specified in Article 22.3 of the DSU. Now, why is this relevant? This is relevant because most developing countries have a very narrow import base, and most of the products which they import from developed countries are in the nature of, let us say, critical inputs or raw materials or capital goods or essential products. So, if as a part of retaliation, a developing country member was to impose retaliatory tariffs on import of goods from the developed country, effectively it would be shooting itself in the foot. So the retaliation would hurt the developing country much more than what it would hurt the developed country. So the possibility of the retaliatory measure inducing compliance in such a situation does get reduced. On the other hand, if a developing country member has the possibility of retaliating on IPRs, maybe that has a greater chance of inducing compliance. But of course, on that aspect, each developing country member which might want to engage in such cross retaliation needs to have within its own domestic law the possibility of suspending IPRs, which are private rights, as a consequence of a WTO dispute. To my mind, even India does not have that provision. So, in a nutshell, developing countries need to move on two fronts. One is in respect of Article 22.3, they need to persist with uh, their proposal on cross retaliation only as a special and differential treatment, and in conjunction, in their domestic law, they must have a provision which allows them to suspend IP rights on the grounds of having won a WTO dispute against a developed country, and in which the developed country was unable to comply with the rulings and recommendations of the panel and appellate body. So I'm going to stop at that. And at the end, I'd be very happy to answer questions. So thank you, ladies and gentlemen, for your very kind attention.
Thank you, Professor Das. Being true to the title that he has earned as academic champion for the cause of developing nations, he did drive home the points that the developing country should consider at the time of negotiation. Thank you, Professor Das. As a final panelist, we have Professor Warner Zudos. He's here to provoke us on the lines if the DSP is moving towards de-legislation or de-judicialization. I'm pretty sure that we will leave the hall after the panel discussion with these questions filling our head as to what is the path that we are moving towards. So let me invite Professor Zudos to share his views on this.
Thank you very much, Professor Lukia, for passing me the floor. And thank you very much for being on this panel again. It's a very distinguished one. There's so many points that have been made by previous speakers that are very thought-provoking, and I'm sure there will be time for a discussion, maybe after this session or at the final session, because many points have been made that deserve further consideration. So my topic today is not to go back to the Molina text or to the existing law. It's to look at this question of where we stand in terms of legalization versus delegalization and de-judicialization. And I think the previous sessions and our discussion yesterday has shown that probably we have to answer both questions in the affirmative. The system as it stands right now in the same state of paralysis is definitely moving towards lesser legalization and lesser judicialization. Whether this would necessarily mean that disputes are no longer satisfactorily resolved is, however, a different question. But compared to the previous well-functioning WTO dispute settlement mechanism, the system has moved to a scenario where governments and stakeholders in business, manufacturers and traders have to confront and explore second-best options and alternatives. Since the paralysis of the AB, most panel reports have been appealed into the void, but some have been adopted by the DSB without appeal. Some believe that would be the rule, that the panel system would continue to function like in GATT 47 by persuasion, by persuasive force, absent the appellate body, but that was certainly not true. We are reaching the number of 30 panel reports that are not, that have been appealed into the void. As can be seen, so even in those cases where, in the minority of cases where adoption has happened, so in that situation, the enforcement stage under the DSU, which Professor Das just explained, the compliance and enforcement stage, it remains available. However, as can be seen with the National Security Panel reports, assuming for the moment they have not been appealed, but most have, and they were discussed yesterday by James Nedunbara. In the absence of the appellate stage, there's no longer an institution to reconcile or to have the final word on legal interpretations or issues of law when different panels adopt incoherent or even conflicting interpretations and rulings. A member would have to comply with the findings of one panel, while another panel may have found no inconsistency of another member on the same issue. So this clearly reflects a less judicialized approach and frankly an untenable approach. So in that situation, we are faced, especially when these national security invocations come from one or essentially one member, a scenario where the defendant will probably adopt and go by the least burdensome interpretation available on the table. So it reduces the legal force and the credibility of the rules. And it, I think the sequence of cases now demonstrates very much why the two-tier system, as it was explained by Ambassador Dasgupta, was invented and was created. We see now how we are regressing here. Now, in most cases, we have these appeals into the void, and the lack of a binding nature of decisions when panel reports are so appealed means that the essential stage that is necessary in the process in order to trigger compliance and enforcement stages are no longer there. So as a consequence, this also cripples the DSU compliance and enforcement rules that crucially depend on a panel and appellate body report being adopted by the DSU. So the reality is the legalistic enforcement rules under the DSU are no longer available. This means compliance proceedings to assess whether measures taken to implement panel or appellate body reports are fully consistent are no longer available. Likewise, arbitrations on the amount of sanctions and the imposition of retaliatory measures with the approval of the DSB, if compliance is only partial or is not WTO consistent, are also not available. This leads to more use of unilateralism that members wanted to eradicate with the adoption of the irregular round results and the DSU. However, something akin to appellate review is available for WTO members that sign up to the Multi-Party Interim Appeal Arbitration Agreement, the MPIA, which was already mentioned by previous speakers. It already entered into force in late 2020, not much more than 6 months after the AB became paralyzed. By adapting DSU Article 25 arbitration proceedings that were actually intended for maybe for a different model of alternative adjudication, the new mechanism was designed to largely duplicate appeals under Article 17.6 So it offers the signatories an alternative. We've heard that there is, of course, the fear that the provisional mechanism could become a permanent one. I would not deny that this is a possibility. But what is interesting to see, and we've discussed yesterday the gap in the Molina document on review and appeal, there is no alternative to this MPIA, even under the most recent paper. So this MPIA among signatories only has basically duplicated the appellate system, and with only some notable exceptions, like page limits, which we have also discussed and heard from the facilitators report, the possibility to invite parties to withdraw claims for the adjudicators, so the MPIA arbitrators can do that, especially when they are challenging the objectivity of panel fact-finding under DSU 11, or the possibility to dispose of certain claims in summary form. Appeal awards under the MPIA are binding upon the parties by virtue of the acceptance of the MPIA, so they don't require the adoption of a panel report by the DSB. The whole process still becomes binding. And then, as a consequence of that acceptance of the MPIA, also the compliance stage and the enforcement stage remain alive. The MPIA has been appraised by now by more than 50 countries, counting the EU member states individually. So, looking at our question posed, it offers a legalistic alternative and shows that de-judicialization is not inevitable. It has also been a positive surprise that the members managed to adopt this within less than a year of discussions, and also to agree on a roster of 10 arbitrators that are quite reputed individuals, and they innovate the system. Maybe I've talked yesterday about any appeal system, any standing body depends a lot on the choice of the individuals. Their background is shifting a little bit from trade expert to also arbitral experts. So in that sense, to the extent there is a difference of views on the underlying philosophy of dispute settlement, this MPIA would reflect a more arbitral approach. But the rulings rendered so far, and they have been too few, show that by and large the tradition of the appellate body has been maintained. But I can see that the fear that some might consider it's another once you accept such an alternative system, it would become yet another nail in the coffin of the appellate body. But it's also a way to resist the pressure of abandoning binding adjudication completely. So the track record is not so bad of this MPIA for the time being. It reflects the majority of world trade among its members. But what is a bit astonishing is the few number of cases, and also, as James Nedumpara mentioned yesterday, even signatories of the MPIA have a higher incidence of settling disputes now amongst themselves through mutually agreed solutions. So, as mentioned, for those that don't sign up to the MPIA, there is no enforcement and compliance review mechanism available. This means that the search for alternatives starts with the compliance and enforcement stage of WTO dispute settlement. Panel reports are appealed into the void. But also appealed panel reports still contain findings, reasoning, and conclusions. If the parties to the dispute engage in negotiations, these findings of WTO inconsistency or WTO consistency may narrow down the issues in dispute as compared to all claims and defenses raised by each party initially. So in theory, this narrowing down of the issues should allow parties to negotiate and find mutually acceptable solutions, which is a bit going back to 1947. However, there are complexities with this approach. To begin with, parties have at that stage appealed or cross-appealed certain rulings into the void and thus disagree and challenge these panel rulings. It is difficult to see how an appealed panel report could be used to narrow down the issues in the light of panel rulings when these rulings remain contested between the parties and appealed into the void. But there are a number of cases, like the one mentioned yesterday with Saudi Arabia and the national security clause under the TRIPS agreement, where the panel report was then used as a basis for a mutually agreed solution, also taking account of the culture of negotiating and settling in the region. It was also mentioned yesterday that seven settlements that India achieved, including in disputes with appeals into the void. But it seems, if at all, a viable option only for less controversial disputes. It may also depend on the area of trade law, maybe not in trade remedies, and the types of measures that are the subject of such disputes. For example, my idea would be that if you think of steel and aluminum, negotiated solutions are maybe to grievances by domestic industries may be more likely, because a return to liberalized trade in this sector is much less likely than in other economic sectors. And if you look back in history, there's a long history of restrictions on trade. There was an attempt to have a separate steel agreement the year around. These seem to be sectors prone to excessive use of trade remedies and maybe not the compliance of law. In such circumstances, manufacturers and traders may be content with second-best alternatives like sharing or dividing up the market, accepting reduced but still illegal tariffs or other restrictions, or finding solutions that satisfy the vital interests of both sides to the dispute. Sometimes, though, at the expense of third parties who are also market participants, and a settlement may be done at their expense by dividing up the market between the main parties. So in some cases, settlements and mutually agreed solutions or compensations for the non-compliance may well satisfactorily resolve the dispute and lead to more tailored solutions for the discriminatory tariffs than the opposition of sanctions or compensation in other trade areas. For example, there was this case in gambling with the United States, where the United States just refused to comply and offered Antigua and Barbuda trade opportunities in alternative areas in which Antigua was, though, not interested in. But there's a big caveat to all of that, and that's why we don't know much about many of these settlements. They are often not published for a reason. When power imbalance characterizes the relationship between the parties to the disputes, it's hard to expect really balanced negotiated outcomes, especially affecting to the detriment of developing countries, I would say. Another alternative has been that governments and their attorneys have started to engage in changing fora at the compliance and enforcement stage in disputes where panel reports have been appealed into the void. However, this is a very complex avenue and faces practical hurdles. Since substantive or procedural rules differ between the WTO and those other mechanisms, the rulings in the panel reports appealed into the void may not fit into the legal standards and the procedural aspects of alternative systems. Nevertheless, this has been tried by using DS provisions under regional economic integration areas to enforce WTO panel rulings, albeit with limited success. And it's also available only among the club of the members of a regional integration area. So if disputes concern disputes between different continents, between different regions, that's not available. Another alternative are arbitration proceedings that give parties much discretion. So arbitration proceedings outside the WTO, maybe private arbitration, could be the governments, could be the firms behind the case, that give parties much discretion in settling the terms of setting the terms of reference, or in determining the applicable law. They could also agree to apply WTO law for that purpose. So these are more capable of serving as alternative fora. They are obviously somewhat less legalistic, getting back to our question, but still quasi-arbitral alternatives. Whether they are actually then complied with and are enforceable remains to be seen, because once you go outside the system with such arbitral systems, it's hard to go back to WTO sanctions and enforcement procedures. The 2024 DSU reform facilitator text places much emphasis on alternative dispute settlement mechanisms under the DSU that are much more flexible than the panel and appeal procedures. The text advocates for alternative dispute settlement mechanisms. We talked about good offices, mediation, conciliation, but it allows each party to opt out at any time. These alternatives are meant to resolve differences and disputes without developing WTO law interpretations. Also, that gives little guidance for the future and for implementation. So these alternatives, as shaped under the new text, may lead to more use, but they are unlikely to ensure coherence of rulings in similarly situated situations and building up a body of decisions that provides guidance and models of behavior to other stakeholders and producers. In the most recent report, the admonition against the notion of following precedent, the call for adjudicators to develop their own interpretations with least reliance on past rulings, and the express or implicit expectation that adjudicators start looking at each case afresh, also regarding interpretations of invoked WTO law, no doubt embody de-judicialized approaches. However, no dispute resolution mechanism can be credible over time, efficient in dispute preventing through past rulings and guidance if adjudicators do not decide the same cases in the same way. Predictability and coherence are cornerstones of international dispute settlement systems, as previous speakers have also emphasized. Guidance for adjudicators not to develop interpretations and avoid gap-filling foster de-judicialized approaches. Absent evolutionary interpretation, adjudicators cannot adapt to changing challenges in the scenario and to changing priorities of members. And we'll talk about that in the next session. The recourse to non-binding mechanisms or regional mechanisms which are limited to like-minded geographical groups offer no alternative to parties from different regions, and this also may lead to fragmentation of the law, which is also going against judicialization. The call for policy space also for developing countries limits judicial review and the reach of international adjudicative systems in areas which would be no longer subject to WTO dispute settlement. But on a bigger picture, let me end on that. The reality is maybe that we have to think beyond how to improve and repair and save dispute settlement procedures as they exist, as they emerge, as they could be complemented with S&D. In a world where members have fundamentally different views on trade, on climate change, on national security, on geostrategic concerns, in a world that faces supply chain disruptions because of friendshoring, of reshoring, there are many reasons why big players and essential players would wish to deviate from WTO law as it stands. And against that background, maybe not such an optimistic outlook, that it's unlikely to reshape or reinstate the binding nature of the dispute settlement system as it stood, because there needs to be, you can shape the rules, you can make them binding, you can come up with ideas about sanctions, cross-retaliation that has been used by developing countries very wisely. It was interesting to hear that repeated by a previous speaker. But if there is not a basic consensus and there are deep philosophical policy differences on how the international system and the trading system should operate, one cannot expect an adjudicative system to save all this and to resolve all these differences. And if it tried, it would probably again face reproaches of overreach. Thank you very much.
Thank you, Professor, for those insights into the functioning of the dispute settlement system. So since we are on a tight schedule, so I was hoping that we could take the Q&A session along with the tea during the break. So that would save us some time since most of the guests have got, early flight to catch. And I hope if there's any question to Professor Abhijit Das, probably we could write to him about it after this. I hope Professor Das, this is okay with you.
Yes, that would be perfect with me. Thanks a lot.
Okay, thank you. So this was indeed a very intellectually stimulating panel discussion, and I guess most of us are celebrating New Year today in many states as well, and we are kicking off our New Year with such a wonderful discussion. I'm happy about it, and we did have a various diverse viewpoints from different expertise with different backgrounds, so that it make this panel discussion a wonderful one. So, with on that note, let me also invite Dr. Anvesha Pal to honor Mr. Atul Kaushik with a small memento for spending time with us, and since he won't be joining us in the valedictory ceremony, so we would want to do it right now. Thank you, sir. Thank you, sir. Thank you, Dr. Anvesha Pal. So also before we have a very short 15-minute break, I was hoping the center members could assemble for a quick photo session with the panelists.
Thank you very much to the Vice Chancellor, Nalsar University of Law, Professor Krishnadev Rao, Justice B.P. Jeevan Reddy Center for International Trade and Business, and all the wonderful faculty members associated. Thank you so much for inviting me to be associated with this esteemed and eminent personalities, and I claim no reason that I should be sitting here alongside these wonderful gentlemen with all the knowledge that they bring to this panel. And the next 1 hour that I will try to have a very tentative conversation with them, given the kind of knowledge that they bring. And I also I'm here like a student of economic laws, approaching this eminent panel, right? The previous panel, Ambassador Dasgupta, set the tone by talking about, and 2 words and 2 issues remained on my mind from the previous panel, and I want to continue those 2 things to this panel, apart from the other things that the panel is going to address, right? So, drawing from the presentation made by Ambassador Dasgupta, he talked about 2 words, judicial activism and judicial overreach. Now, these are not the words that have just come in the recent, discourse on the appellate body and the appellate review process itself. But I take you back in mind to a 2019 panel discussion at the World Trade Institute, which was chaired by Professor Gabriel Massot, and it also had participants from, national missions at Geneva, and also some members from the trade law practitioners circle. So Professor Marsu also asked whether there has been any, or whether there is any legitimacy to the argument that the US has made, while the US specifically did not use these terms, activism and overreach, but by talking about member control and taking back. Was the US actually hinting at these 2 words, or is it that these are just semantics? We have one of the most experienced, dispute resolution personality amongst us, who has also served as chair of the appellate body. I would want Ambassador Bhatia to, address us as students, trying to explain why at all the US has made. Now, given that this panel is actually talking about, navigating the future of dispute resolution system, I was just thinking that a little bit of reflection on why we have come to this current crisis, if I may call that word, and also the crises, much of the discourse in the last 8 years or so has been taken over in the academic spaces by these terms or the synonyms of these words. So I was just hoping that before we move on to the other topics that we have outlined for this particular thing, I was wondering if the experience of Ambassador Bhatia on the chair of the appellate body could actually help us understand as students of trade law, if there is anything that, because as students of international law, we've always understood that there is a certain VCLT method of interpretation. So if that is something that is the gold standard that has been followed across, then why is it that the US is actually raising this claim at all? Thank you so much. And I request Ambassador Bhatia to recognize. Thank you.
Thank you. Thank you, Ramani. Thank you also for the generous introduction. I think this is a session with a slight difference. We are not addressing the issue of how and whether the DSS can be reformed. The question we are addressing is even if the DSS is reformed, given the changed global situation, can it perform its intended function? Uh, and I have a small comment before I start, which is that I think there are limits to how much wisdom old people like us can have. I think wisdom has to be an interactive process. So I propose that we discuss, I will confine myself to only about 5 or 6 minutes, and hopefully we will have time for more wisdom from across the podium from the young students, because I think it has to be a two-way process. And one regret I have is that we have not had enough time in the previous sessions to exchange ideas and views with our young student community. And I see that we have a very interesting audience here, including some four-legged ones. So let's start. Uh, and I think I will start with the question. Let us assume that miracles do happen and that the dispute settlement system is restored to its binding two-stage structure by the end of this year with appropriate changes. And the question I would like to address is, can we then assume that the crisis of the dispute settlement system and of the WTO is over? I think it's also important to bear in mind, and this is something which Werner referred to in the previous session, any adjudicatory system functions in a social/political context and is not an island in itself. Such systems are also evolutionary, but for that, they require a certain legitimacy among the stakeholders. So the question is, given the changes that have taken place in the world in the last 30 odd years since the rules were negotiated, will the dispute settlement system have the necessary legitimacy and authority to adjudicate on disputes which arise from new global concerns, new global priorities, and so on? Let me point to a few issues which I think are very important in the context of global changes in situations, in priorities, and so on. The first, of course, is geopolitics. And while the rise of China is generally cited as a major issue, but there are other issues as well. And these have an impact, an obvious impact on the functioning of global value chains. And you have new words like friendshoring, nearshoring, and so on. And as a consequence of all that, we have the rise of industrial policy. And I think Leila has already explained to us the ramifications, the implications of the dispute that China has brought against the United States on the tax credits in the IRA. But the United States is not alone in pursuing a very aggressive domestic policy, industrial policy. There are other players also as well, the European Union, Japan, India, everybody has got into this act. So how are the WTO rules affected by these kind of policy changes among important members? The second is an issue which is very important for all of us, the climate change. There is in the WTO no consensus on a mandate for discussing climate change. And what we have just started to witness these things. We are seeing unilateral measures being enacted like the CBAM in the European Union. Now, there are apparent conflicts between trade law and other international agreements. And I think the thing to point at is we have an agreement called the Paris Agreement, where we have nationally determined contributions, NDCs. How do the NDCs work with measures like CBAM? This is an issue which will inevitably come before the dispute settlement system. How does the dispute settlement system resolve this conflict between trade rules and commitments in other international agreements? The third issue I'd like to point to is the very broad issue of digital transformation. And as we all know, there is a vast gap in WTO rules on digital issues, especially on issues like data transfers. We heard this debate recently in the ministerial conference on the moratorium on e-commerce. But that is the tip of the iceberg. There are broader issues. As I said, data transfer rules are in their infancy. We have now the issue of artificial intelligence, and there are no international rules on the governance of AI. So we have, for instance, IPR issues like copyrights, when AI models are using other people's intellectual property. Then there is an issue of, and this is very important for countries like India, we have the issue of a digital divide. And let me point to one particular technology, which is 3D printing. We may not think it's very serious, but 3D printing has been growing at more than 20% in the last several years. And there are some estimates that in the next 2 to 3 decades, something like a fourth or a one-third of global trade in physical goods will be covered by 3D printing. You can imagine the impact, the cross-border flows of physical goods being reduced by that kind of magnitude, what impact it will have, for instance, on developing countries, because many of these goods which are amenable to 3D printing are goods in which developing countries specialize, like textiles and clothing, like toys or automobile components, footwear, and so on. We are talking about the employment of millions and millions of people. Then, of course, there is the large issue of national security, and I think I need not elaborate on that. James made a very, very good presentation on that yesterday. But this entire position of the United States, for instance, that invocations of national security are self-judging. Now, how does the dispute settlement system adjudicate issues which are so fundamental to the views of important members like the United States? For instance, in the IRA tax credits dispute, if, for instance, the panel has the audacity to rule against the United States, can we be sure that the United States will comply? So broadly, this leads to a bigger formulation, which is the mismatch between a dispute settlement system functioning on the basis of 30-year-old rules and present realities of international commerce, which are totally different from what they were 30 years back. So even a reformed dispute settlement system without a change in rules to reflect new global realities will be put in a very, very difficult, very unsustainable position. It will be again accused of the issues that Ramani was talking about: judicial overreach, making law, changing the balance between rights and obligations, and so on. So, and it is very likely, unfortunately, that some members may not accept rulings of the dispute settlement system in that situation. So the only sustainable solution to this problem is to address the paralysis of rulemaking, and that, of course, is easier said than done. Thank you.
Thank you, Ambassador Bhatia. By stating that you're putting the adjudicatory system in a particular social political context, I think you actually answered, the kind of query that the way we should address these issues of so-called activism or overreach by looking at the social political context that you are stating about. Yeah. And again, going back to the previous session where Ambassador Dasgupta talked about the multi-party interim appeal arbitration agreement being flawed. I understand that he's talking about India's position on that, but I was just wondering if he would, since there is a lot of discussion around the multi-party interim appeal arbitration, the nomenclature itself shows that, by calling it as an interim, we are looking at it as a kind of an interim, situation addressed to the kind of crises that's there. But I'm just wondering why India actually considers this as a flawed agreement. So probably Ambassador Dasgupta can reflect on the plurilateral at this stage. Yeah. Thank you.
Thank you very much. I think Professor Werner spoken about the MPIA in some detail, but from what is publicly available about the MPIA is that approximately, I think, including the EU, more than 20 countries have joined. So the total comes up to, I think, 40 odd now. Is it correct?
Around 50.
Around 50. So it is out of membership of 166. It includes approximately 50, which has the European Union, it has China, it has Japan, it has Korea, it has Canada. Now, there is this push and shove, which is being also applied to force countries to join the membership of the MPIA, in the sense that I think the EU has and Japan have passed some kind of legislation, perhaps, that if a country does not join the MPIA, then certain benefits which accrue to them through the dispute settlement system will be denied. I am sure Professor Dezouk will mention further during his presentation. So that is one point, that in a multilateral system which we are trying to uphold, we can't have these kind of unilateral measures. And Ambassador Bhatia has so rightly pointed out about CBAM, which is creating all kinds of controversies. And it has already come into effect from the 1st of October 2023. Of course, it's yet to start biting in that real sense. But it is going to create many problems. And the MPIA, if it were to decide on such issues, the panel of, there are several things which come to mind about the MPIA. One is that its membership is still restricted. It does not have a very wide representation. Less than 1/3 of the membership is signatory. Two, very importantly, countries like China, which have signed on to the MPIA, are they referring all the disputes to MPIA where they intend to appeal? Or they are keeping their options, or they have one foot in this boat and another one in the other boat? So that is, again, a flaw, because they're not giving up their option. Not all cases where they have a matter to be adjudicated upon either through arbitration or appeal, they're going to the MPIA. The third thing is about the selection of the MPIA members in the arbitral tribunal or body, it's been mentioned that there are 10 members who have been chosen, very eminent members. I have nothing against them, that they will be chosen at random. Now, if you look at the appellate body, it has 7 members, and traditionally, the larger your share as a country in international trade, your claims are that way stronger to have a member on the appellate body. So, right from the beginning, there has been one US member, one European Union member, one normally from South America, one from Asia, or 2 from Asia, one from Oceania, it could be Australia, New Zealand, other countries, one from Africa if possible. That has been the general share of appellate body membership. Now, initially, as in the case of the dispute settlement panels, it was decided that if one of the 2 countries, complainant or the respondent, you couldn't have a dispute settlement panel member belonging to either the complainant side or the respondent side. They tried to follow the same system in the appellate body in the 90s, soon after the WTO came into being. But they found that most of the time, the US and the EU members of the appellate body would sit idle, because the US or the EU were involved in either appealing or in responding to the appeals. So that was simply not possible. And 2, because the members were of a certain level of eminence, impartiality, neutrality, it was expected that they would rise above uh, their connections to their own country's policies and measures which they had been adopting, and they would decide issues strictly on the basis of their intellect and understanding of international trade law. So it was decided formally that if there was a member whose country was either a complainant or a respondent, then that country's member would be a part of the appellate body panel of 3. That is why, after Mr. A.V. Ganesan became a member of the appellate body in the early 2000s, I think, and then Ambassador Bhatia, all the appeals of India have been heard by a panel in which they have been members. And similar is the case with the US and the European Union and other countries. In this case of the MPIA, they will choose the panel randomly, is what I have read in the publicly available information which had been put out. And there are only 10 members. So, how are they going to choose the members? That is something which is not very clear. The last point is about compliance. What happens if a country which has been asked to bring its measure in conformity, of course, it's an arbitration arrangement, so there would be some pluses and some minuses, but at the end of the day, you can't turn the clock back and ask for retrospective effect of an arbitral agreement as in a normal arbitral agreement, because that is again outside the purview of the WTO jurisprudence. For instance, in a commercial dispute, I am an arbitrator also in commercial disputes. You say that, all right, you pay compensation to this amount because you have made the other side incur a loss. In the WTO, there is nothing of that kind. It's only prospective. And you bring your measure in conformity. That is the best that the WTO panel or the appellate body can recommend. What does the arbitral arrangement recommend apart from this? And if a country refuses, or is, it raises further issues, who adjudicates? What is the mechanism which has been given in the case of the WTO through the compliance panel, through retaliation? Those things have been left unaddressed, to my knowledge. So that is why these are just some of the preliminary objections or observations I have to make about the MPIA. And finally, the most important objection is that, you have things like, and I hate to mention this, a two-state uh, proposition since 1948 that Palestine will be a separate country and Israel would also have its own independent existence. An interim arrangement which has continued from 1948 to 2024, it's still continuing. It is effectively not been implemented. So that is what happens in many cases in international agreements or pronouncements, that interim arrangements have a nasty way of staying on beyond their sell by date or date of expiry. That is a problem which India does not want to face, that it will effectively substitute for the appellate body. It would be a kind of still an arrangement which would be a second best option, and the powerful will still hold sway over the less powerful in terms of implementing the decisions and in terms of redressal of the problems which have been complained against. Thank you.
Thank you, Ambassador Dasgupta. I was just wondering that MPIA's inspiration being Article 25 DSU and especially Article 25 Clause 4 DSU. So how would when you say that there are issues with regard to the compliance and all such activities, ensuring those things, I was wondering if you see that as a significant flaw, given that the inspiration is pretty well spelled out in Article 25 DSU. So also hoping Professor Zudos would actually reflect upon this, and then we come back to hear from, Professor Zudos, please.
Yeah, on this one point, very valid points. On this one point, 25.3 sees that the enforcement system does come back, so it's applicable, and members that sign up to the MPIA would bind themselves to the compliance according to the DSU again. How this works out in practice with arbitration awards and so on, obviously one cannot deny the principle is there, it's binding, but how it would be implemented on the basis of these arbitration awards, there would be work to be done.
Just on this point of when we are talking about Article 25 and then comparing it with the MPIA. Now the practice under Article 25, whatever the jurisprudence we have, is very limited, but there are two clear paths that we could see. The Turkey pharmaceutical products case actually preferred the use of Article 25 in an appellate method, whereas if you look at the US copyrights matter, they actually looked at it in that a textbook definition of the word alternative that was laid down in Article 25. So, I mean, as a trade law scholar, I was expecting if Professor Zudos can, speak on his reflections on should we have both these methods open, or should we persist with the idea of an interim appeal arbitration agreement, plurilateral, like a temporary measure? Or why not take the path as seen in the jurisprudence under Article 25, like look at it as a clear alternative? I was hoping Professor Zudos would reflect on it.
Sure. I mean, I think I'm not wanting to propagate a particular model here. Obviously, we would be all wishful that the appellate body comes back in its old glory, but the realities may be different, and then there's an interim solution, but there also are arbitral solutions, or maybe the geostrategic powers that dominate the world now, as Ujjwal explained. I mean, I might want to go back a little bit to the bigger picture again, because I think it's very important to, in this final session, to look at the proposition of Ujjwal Bhatia that suppose we are back to a functioning VSU or a functioning MPIA or arbitral systems that work perfectly well. Would that system then work? And I think my thought, taking it further from what Ujjwal has said, I don't need to repeat what he has said, is I think rather than camping on the rules as they exist, we would very much need to even give up the compartmentalization of trade law from other areas of law. All the new issues are intertwined. There are repercussions, interlinkages everywhere. Ujjwal explained the climate change issue. It's not a coincidence that the treaty was negotiated in the forum where it belongs to, in UNEP, but the first issues that come up are in trade, because goods are traded with different carbon footprint in it. And it's inevitable, the same with the subsidization. Many countries in Europe, America, pour billions into the transformation to have a more sustainable energy supply. And again, this raises huge subsidy issues. And I think I've been thinking a little bit, because Ujjwal shared his view with me last night, to give you some examples of the challenges that would be faced, and that goes back to your initial statement about the risk we would be taking again to burden whoever the dispute settlement of the future would be, to burden that system with impossible tasks. And to give you maybe 3 examples, and one of them would be e-commerce digital transformation. The whole architecture of the GATT is from the 80s, from the 70s of the WTO covered agreements concluded in 95. Even the Doha Development Agenda is more than 20 years old. And we have had these negotiations going on now for decades also in e-commerce. And there are, of course, issues that require expertise. What does WTO delegates and staff know about cyber crimes and all the digital issues that can arise? So there's this expertise part, but we've seen the WTO can grapple with that. Years ago, we knew nothing about fisheries. Now we have a fisheries agreement. We relied on expertise from the FAO, and then it was built up in-house, and the members sent delegates not only from trade ministries, but also from environmental ministries. So this gap of knowledge and capacity can be bridged. But structural questions have never been addressed because, for example, e-commerce, we have this wonderful compartmentalization between GATT's TRIPS, but in fact, e-commerce affects all the 3. And if you want this new agreement, if it ever comes about, to function, you may have to rethink the structure, because you almost need the 4th pillar of the WTO, because e-commerce will be cross-cutting. Another thing is, when we talk about the moratorium, maybe it's really time to let it go. Many would say, no, is it even fair to classic traders that they will be taxed? And if you buy the same thing through the internet, it will be tax-free. This is uneven taxation, and revenue generation is necessary for governments to carry out its functions. But if you start doing this, how would you operationalize digital taxation? How would you know what is unfair, what is discriminatory? And the same thing applies to the idea of supply chains that are disrupted. The model of the WTO is built upon one country picking up the case of a company along national lines. Supply chains are transnational. Servers in e-commerce are in different countries than users. Often we don't even know under which jurisdiction the suppliers are. So do we need to get standing rights to bring cases to different companies, to different users? You even have to challenge yourself thinking whether the classic notion in dispute settlement, there is one state and one claim and there is one product, and you can nicely compartmentalize and allocate it and distribute it to one sovereign state. Also, this may not work in practice. When we talk about investment facilitation, whether you like it or not, trade and investment is interchangeable. And again, you need to look at this coherently, maybe with other fora, maybe within the WTO, maybe with the FTAs as a playground for better clauses than BITs used to offer them, where the host country protection is also important, not only the investor protection. But all these issues need to be looked at coherently. I mentioned supply chains, and Ujjwal already mentioned the question of climate change. It's a huge challenge that it's a bit the model of tariff concessions that we have in the GATT and concessions and commitments under the GATTs. It's comparable to this notion of nationally determined contributions that you have in climate change. Again, how do you know what is really equivalent, and why does this matter? Because when you then have discriminatory taxes or products that are more highly taxed because they are less environmentally friendly produced, you will face trade restrictions, and then you will try to justify them under Article 20. It will be an easy fit under health and conservation of natural resources, so the subparagraphs won't be the problem. The problem will be the chapeau, the introductory clause of 20, where maybe the clause that you're only called upon not to discriminate between countries where the same conditions prevail. What does that mean? It's a Pandora's box that in dispute settlement wasn't touched, but when it comes to looking at climate change measures of different countries, the Europeans started it, but they triggered the debate in other countries, and other countries are doing the same. So you will have to think about, can you distinguish and do you allow as an adjudicator discrimination between countries where the same conditions do not prevail on the basis that some have better climate change standards than others? So these are issues that need to be resolved, and I think these are just examples to buttress the point that was made by Ujjwal, and I think I tried to say that also in the previous session. If you simply restate the dispute settlement system as it stands, and you throw these new issues at the system, the room for questioning the balance between the judicial branch and the negotiating branch and overreach, or whatever you want to call it, will resonate again. And one of the solutions there would be to intertwine more the organizations that are dealing with this. When you talk about the pandemic, the waiver from the TRIPS agreement in certain respects for essential medicines, there was a huge effort to collaborate between WTO, WIPO, the Intellectual Property Rights Organization, and WHO, the Health Organization. And many of the efforts were concerted, and the solutions will only work if they are concerted. You're trying to not violate patent rights, trade rules, but also respect the human rights to health. And I mean, when you look back in history, obviously it's maybe very creative, but it to some extent not. Already in the Havana Charter of 1947, that was not then adopted. So the International Trade Organization, that was contemplated at the time as a complementary to the World Bank and the International Monetary Fund, there was a process foreseen that was very innovative, intertwining this ITO with the ILO. So if there had been a case where labor standards or labor rights are implicated by a dispute, the ITO would have sent that question for adjudication or an expert opinion to the ILO, and on the basis of what the ILO tells them, they would come back and then decide the case. Now you can of course ask yourself, should that be decided on an international level? Should this be left to domestic policy space and so on? But there are models available where you start intertwining these different systems. And my plea would be to, maybe you can formalize this, maybe dispute settlement panels could hear experts from other organizations, as happened in the WIPO case. You've mentioned the copyright case where this happened, that the panel heard the experts from the WIPO. I think we need to think big in terms of trying to reconcile all these different legal regimes, because nowadays trade and telecommunications and health and climate change, it's all not separable anymore. And one way is to think, to fear again about the loss of sovereignty. Another way of looking at it is that looking at this at an international level coherently, you prevent that governments are facing conflicting obligations, that they have entered into conflicting obligations if all these regimes don't work together but against each other. I stop here.
Thank you for Professor Zudos for flagging some of the important issues and taking forward the discussion where Professor Ambassador Bhatia said the ball rolling on those points, trying to set an agenda beyond just being embroiled with the dispute settlement systems issues as of now. Now, before I open it up for the students, I also was wondering if Secretary Kaushik can actually reflect on India's engagements at the recent ministerial, where some of these issues were flagged, some of them were notified as items for the next ministerial, but on a few issues, especially on electronic commerce, India did make a statement on that. So I was wondering if Secretary Kaushik can actually reflect on that engagement.
Thank you, Chairperson, and thank you also for rebalancing, at least to some extent, the gender imbalance on the panel here by joining us as chair, as you mentioned, and you were talking about 4 gentlemen, so we have you. I also, let me take this moment also to respond first immediately to your question relating to India's stance on the e-commerce moratorium in last month's or February's ministerial conference. The stance is based on publicly available information about the developing countries requiring revenue for undertaking their development, growth, and welfare pathways, and the growing remit of e-commerce related transactions makes it a bigger chunk of revenue that they can generate. There are questions being asked about whether we are counting certain e-commerce transactions in those numbers that, for example, UNCTAD and other organizations have come up with, which would in any case be a part of the ongoing tariff rules that the WTO has. But nevertheless, even if we discount those numbers, there's a significant revenue issue. And it is not just India which has that position. A lot of developing countries, almost the developing countries who have taken a position on it, have taken the position about the moratorium having to go. The quandary that the delegation was facing was that nothing else was happening in the rest of the issues. But we had to have at least a decision on those issues where the ministers were expected to not allow an existing issue to lapse. And therefore, there was a compromise, and India has agreed for another 2 years of continuation of the moratorium. But this brings to the larger question that was the theme of this subject, and Ambassador Bhatia and Mr. Zadok has, in a very articulate fashion, mentioned the larger, you know, the larger gamut of issues that are now going to more and more inform how WTO works, and whether and in what manner the dispute settlement mechanism of the WTO will be operationalized going forward. So if you permit me, Chair, I'll spend a few minutes on that aspect also. One thing that we need to understand is that we are living in a VUCA world: volatile, uncertain, complex, ambiguous. And this requires a multidisciplinary approach to anything, not just trade. A consequence of that is that it is probably now not going to be possible to leave WTO work, WTO negotiations, and implementation of WTO obligations only to trade lawyers like me. We would require economists, but also students of international relations, those with a particular disciplinary interest in geoeconomics, to be in the room, to be able to get a hang of what exactly is the menu on the table and how to move it forward. Now, one of the problems that we have faced after the Cold War days is that the international policeman is not able to call to order quarreling friends and foes, like it could do earlier. Even though the only country that policeman considers as a competitor is not one of the quarreling sides. So this is something that provides a fillip to the VUCA word, which we are facing, and therefore we have to be even more interdisciplinary in your approach, as Mr. Zaduk said, even in the WTO. The third point is that, rather than using tools of the halcyon days of multilateralism, like the UN Charter, the International Court of Justice, and of course, dispute settlement mechanisms of the WTO and dispute settlement mechanisms of the FTAs and others, what is happening now is that the major stakeholders of the global economy, they are either using unilateral measures, at least those who can or can afford to use unilateral measures, or they are having a very transactional and mostly bilateral approach to pursue their economic agenda. Some, of course, are becoming regional in their approach, and that region is not necessarily defined by geography. Take the Indo-Pacific Economic Forum, where rather than binding negotiated commitments like the other typical trade and investment related agreements, they are working on supporting their industry through mutual understanding on issues like supply chains, on clean economy, on fair economy, on trade, and based on a framework of collaboration rather than what we typically call in the VCLT word, as you mentioned at the beginning, Chair, a treaty. So it's more a framework than a treaty. They are probably satisfied with it because they are saying a lot of progress has been made, at least on 3 of those 4 pillars on which they are working. So while on the one hand, global priorities can be clearly defined and they have been mentioned, addressing climate change is one, achieving sustainable development goals, particularly for developing countries, is another, reducing conflicts and contestations solutions requiring, reducing these contestations are also available. At least they are a part of the discussion. We have the requirement of funding in issues like climate change and SDGs, not happening. We have technology transfer at an affordable, on affordable terms, which is not happening. We have to have an approach of comity of nations where issues like common but differentiated responsibilities have been multilateral approaches. They are not happening, at least not in the new found ways that individual nations have used to address climate type challenges or pandemic type challenges. So there are few buyers for these approaches. In this scenario, what do we do? The dispute settlement mechanism of the WTO, to my mind, remains a chimera, and this has been, mentioned by the others also. So in this situation, probably each country has to first take steps to get their own house in order. So in terms of solutions, there are not many. But what I can say from the Indian point of view is that we have to have a case-by-case assessment on how to handle, each contact, each dispute, each transaction. I remember when I was the legal officer of India in the WTO, though in those 4 years, we had 9 disputes in terms of consultation requests, and they were maturing into establishment of panel requests. We could resolve all those 9 uh, bilaterally through using diplomacy and uh, talking with the complainants. So can there be a better coherence between the trade and the foreign affairs communities is one step. The second is we have to let it go for now and let the pressure build from the industry. The GATT was created by the industry. The WTO was created by the industry in the sense that there were crises that the industry faced, for which remedy was having predictable trade rules. And now also this lack of security and predictability is going to eventually hurt the industry, and the industry is going to get back. And it's a very potent constituency for our political masters also. So they have, if their resources dwindle, they're going to look up to the industry, and that industry is going to ask them for something in return. So wait for that. And in waiting for that, we have to, of course, continue our engagements in bilateral, in regional issues, take steps on how we can manage this transition in the best possible manner. And in the meanwhile, take 2 steps within the WTO also. One is try to make incremental improvements in a common understanding of what kind of a dispute settlement mechanism would work. Today we have, uh, you know, geographically very polar positions on what should happen, and we have discussed that in the last 2 days. But we have to still continue incrementally finding and chiseling away, those areas on which there can be a understanding. And the second is for India in particular, I think there has to be a reassessment of its approach to some of the newer issues and also some of the newer modalities. Uh, I am not saying that the position that has been taken by India so far has any flaws, but not to speak of issues which are domestically and in terms of our industrial policy and trade policy at the top of the mind of policymakers in the country, not being a part of their conversations internationally is a kind of a bewildering aspect. So yes, it needs to be discussed, and you need to get to the table to talk about these issues, not necessarily in the current form of joint statement initiatives. We yesterday discussed, how the informality of negotiating subjects can be formalized. So we have to find ways to formalize in a manner that is equitable to all who are in the room as well as those who have remained outside the room, and find ways to bring all these issues together, like Mr. Zedok said, involve maybe multilateral environmental agreements and other institutions also, with which you can have some solutions. I am not saying it's going to happen overnight. I mean, you gave an example, Professor Zeduk, about the pandemic waiver. The pandemic accord that is being negotiated in WHO and WTO and WIPO and WHO have been having these annual inputs into this process through very well designed conferences. But the result is nowhere to be seen. I mean, we are coming to the WHO assembly shortly in May, and we haven't found a resolution to uh, gaping holes in the text on the pandemic accord. So there are going to be challenges, therefore patience, and let the industry start calling the shots with the governments. Thank you.
Thank you, Secretary Kaushik. Let me take a moment here to acknowledge the presence of Dr. P.S. Rao, who has joined us at this point of time. Good afternoon, Dr. Rao. Thank you very much for, arranging this session for us. Thank you. Yeah. I know I'm kind of asking you a few more minutes, and I'm standing in between you and your lunch, but I promise you there is more to come in this intellectual treat that we are having here. And at this point of time, I know at the previous session also promised some time for your questions and for all your queries. And we have the eminent panel waiting for us.
Right. If you allow me,
Yes, Dr. P.S. Rao, please.
I'm most grateful, really. I'm thrilled to hear 3 or 4 excellent reviews about the role of dispute settlement in a system of trade arrangements in the WTO, where the arrangements themselves are changing their dynamics and their color and content in terms of issues that they generate from now on. What they have generated until now was a different set of background around that came through a traditional mode of trade and business arrangements. And the number of sectors that WTO covered ranged, even though even the earlier stages also, the environment was covered until for a point of time. I remember I even gave a lecture in Pondicherry a long time ago about environment and trade issues. But then Mr. Jeduk has pointed out extremely well in how many ways the new systems, like I spoke yesterday for a few minutes, he has given content to my thoughts, which were very general and very impromptu ones. That is, can we really have a good settlement dispute system when the substance of the law itself is not very clear and is undergoing tremendous changes? And if the substance of the WTO arrangements are now have to be taken a good fundamental look at what they are and what they could be from now on, would that not determine the kind of dispute settlement that would it require, which may be different from what we have? And I think the suggestion has been made very well in one of these comments of a very extremely knowledgeable panel we have. And in fact, I would like to take this panel as my mentors for the center to continue to debate these matters and then take one issue at a time, if possible, to see how a new scenario could be developed in terms of not only the substance of the law itself, but also in terms of any dispute that might arise out of that particular substance. Climate change, for example, very well pointed out, if there are no obligations for states to move in from their procedures of adaptation without technology transfer and financing that should be necessary, how can one then go for a kind of indeterminate obligations in terms of climate change to be transferred in terms of trade subsidies, etc., etc., and the kind of interaction that these two will have in terms of settlement of disputes is quite clear. A compulsory settlement cannot be the answer, because compulsory settlement, as you know, as a student of international, I can tell you, has been opposed right from the beginning, because there is no agreement on the substance of the law. Even though charter was there, charter itself was so vague and general at that time. And as one of our ambassadors have pointed out today, the four policemen have abandoned their duties of policing the world and only policing each other, and then pulling us into their orbit, as it were. And that's why non-alignment came out. So under the circumstances, the political scenario that is governing the trade and business at the moment, thanks to the climate change, thanks to cybersecurity, thanks to the multilateralism that has been non-functioning, but otherwise everything is affecting everybody else, whether you like it or not. Given this scenario, what kind of a new arrangements can we look at on a given case by case basis, and to see how that new arrangement would then be handled in terms of a dispute settlement, rather than looking at dispute settlement as a separate issue. I will close this statement with only one personal experience. As Bhatia would know, that I normally speak of personal experiences because of 60 years being in the subject. When the law of the sea commenced in 1950, 61, 62, second conference, first conference was 58, 4 conventions were there, mostly on customary law basis. Then by 67, when Pardo raised this issue of manganese nodules, the whole law of the sea got opened up. And for the next 10 years, we were renegotiating the entire law of the sea convention, both from the traditional point of view and as well as the new circumstances that were there. And it took 10 years for us to get the 1982 convention going. But that convention could not come into play another after 10 years, 1994 and 95. And then thereafter, some settlement of dispute system started working. So can we put the horse before the cart? That is the question now. Settlement of dispute should come after we have a consensus on the substance itself. And I think we need to relook at the entire WTO system, even as we are looking at the possible ways of rekindling a reasonable level of settlement of disputes, which is acceptable for a particular case by case basis, as one of the speakers just now said. I hope these are my initial thoughts, but I'm really thrilled by the composition of this particular working group, which has educated us and brought me back into thinking that we need some fundamental thinking about the substance itself, rather than worrying about the particular aspect of a dispute settlement procedure. Thank you very much.
Thank you, Dr. Rao, for that insightful intervention. I really don't want to hold myself in between the students who have been eagerly waiting for having their time here with this eminent panel. So I invite questions, and if you don't mind, can I just take 20 minutes of your time before lunch? Thank you. Yeah, could you please identify yourself first, and then we're trying to reach out to you. Just hold on for a few seconds. May I request you to keep your questions brief so that we can have more
Greetings to the
students.
panel. I am Kishore Prakash. I'm from South Asian University. I have the question to the Mr. Jayant Das Gupta sir. So my question is, like one side, India call for the restoration and reform of dispute settlement mechanism. At the same time, they have also recalled the commitment made at the Ministerial Conference 12. On the other hand, previous to this commitment or recall, we have seen the India's action indulgence in the appealing in void. So my question is that it is not diluting the India confidence leading towards the revival and restoration of appellate body.
I'm sorry, I could not quite get your question very clearly.
So I wanted to.
Yeah. Yes. Now, Professor Atul Kaushik has explained. I think it is personally, it is not at all contradictory, because if we were to, if India were to put all its efforts behind the revival of the dispute settlement understanding, along with a two-tier structure with the appellate body, not at the MPIA there, which is in any case only an interim arrangement. So if the appellate body were to be there, then if you were to, through your other actions, communicate that you are not very clear whether you will be achieving your objective, in fact, you are quite unsure, and that is why you are not even preferring an appeal, that I think would be the wrong message to send. So, what we are saying as India, and I am not a government functionary any longer, but I think India is trying to convey this message that it stands solidly by the restoration of the two-tier structure in the shape of the appellate body, and that is why it hopes and expects that the rest of the membership will rally round and restore the appellate body, and that is why it is appealing into the void. So if it has certain issues about a panel report, it can wait till the appellate body gets restored for the redressal of its disputes and grievances. Thank you.
So I wanted to ask Ambassador Bhatia about the digital trade. So I do see that there are some countries where they negotiate particular provision with regard to digital trade in their treaties. At the same time, I'm actually anxious whether India is in a position to have such kind of negotiation at the treaty level, or do we have to strengthen the national policies with regard to maybe data protection policies or with regard to data transfer and all of these issues? So what would be the best strategy for India in order to proceed in this direction with the growing significance of digital trade? Do we have to make a huge leap, or or are we catching up to other countries who are negotiating particular provision in the treaty? So I just wanted to know what would be best for India in such case.
Well, for the moment, India does not support such discussions in the WTO. And I think it would be useful to look at what is India's interest in the future, in the present and in the future, in terms of the digital transformation. And I think among developing countries, perhaps there is no other country in the world except India which has the maximum potential of taking advantage of the digital transformation because of the huge infrastructure, the huge human resources that we have. I think this is my personal view, of course, but I think we need to capitalize on that in a big, big way. We have nothing very much to be defensive about. So I think going forward, India stands to gain by an international governance mechanism, a set of rules for digital commerce. And India has certain sensitivities in terms of data protection, for instance, data localization, in terms of privacy and so on and so forth. But these are issues which can be negotiated. India is not alone in having such concerns. And I believe that these concerns can be negotiated in a broader setting. But the larger issue that we stand to gain from this digital transformation, I think this is something which we need to recognize for the India of the future.
Good afternoon, sir. So my question is to Professor Vanadok. So, like, as you have touched upon this area, like if the panel appellate body has been restored, how they're going to function if the other issues like environmental concerns have been taken care of. So my issue is very particular in terms of industrial subsidies, which China is actually using. If in that case, if appellate body is being restored, how it would be dealt by the appellate body in terms of industrial subsidies? Thank you.
I think this is a very good question and a huge topic. I think again, I do think that we shouldn't separate the reinstatement of the procedures from the substance of the law. And I remember the dispute that then was appealed into the void by India and happened after the appellate body became paralyzed, which was challenging export processing zones as prohibited import substitution subsidies. I think maybe there was excessive use of this. China is challenged on this a lot. But again, my personal view on this is that these rules were shaped in the 1970s and 80s. Again, not with enough participation by developing countries. And that's why I would very much endorse what Ujjwal just said about e-commerce. Be there at the negotiating table. Don't let the train leave the station and then later on you cannot reshape the rules as well anymore. Just as to mention in this context for e-commerce, we have a model for such a treaty, which would be the trade facilitation agreement, where developed countries have full obligations, advanced developing countries lesser, and for least developed countries, there's a fund and they will be helped to build up capacity, and only once the capacity exists, they will assume obligations. And that's also, to the previous question, it's almost something you could do within India, where seems to be a south-north divide, in this respect. But going back to the import substitution subsidy, I think it was, I remember disputes where sometimes even the complainants or the parties were actually surprised by the rigidity of the rules we have in the SCM agreement on import substitution subsidies. And if import substitution is done in order to engage in beggar thy neighbor policies, then probably that's justified. But if you want, as a developing country, to increase the value added by processing more at home, there's still this infant industry protection provision from the old GATT that is sort of sitting there dormant. We have to probably reconsider somewhat the rules. And there was a study done in the WTO recently that was called industrial subsidies, which is a bit a code word by some Western countries, and it's very China-oriented. But in the end of the day, you need to rethink the rules of the WTO more generally, where the government is a market participant and engages in the market. And for the longest time, this was considered to be something the trade rules need to just constrain and eliminate, and countries acceding to the WTO were told, you need to get rid of it. It's a reality. And actually, when we talk about the climate change measures, they were all mentioned. Everybody does it. And, you know, the appellate body was criticized on the renewable energy case, where Ujjwal mentioned yesterday fervently by some economists some years ago that it was ruled that the energy markets that are renewable and non-renewable are not necessarily the same market, and you can have different market regulation for those. In the meantime, I think this has become a leading case. And so my answer to your question would be that these industrial subsidy rules that exist in the WTO need to be rethought. There needs to be a green box of justifiable subsidies that comes back, not only on climate change, but also on rural development. we're talking a lot about inclusiveness, women, the informal sector, the agricultural sector. There needs to be policy space for governments to do that, and maybe not only with subsidies that some members cannot afford, but also with other incentive mechanisms that need to be permitted in order to increase the value added generated in developing countries.
Hello. Very good afternoon to all. My name is Rudra Singh. Sir, right here. I'm a student of Faculty of Law, Delhi University. So, ma'am, I have two questions. My first question is for Mr. Kaushik. And the question is, sir, when we have these kind of international issues and these countries try to come up with a solution. So during these time, I think what the conflict there is countries are trying to be the leaders or initiators in the field, trying to come up with the solution, and on the second hand, they are compromising with the efficiency and effectiveness of the solution they are coming up with. So what are your thoughts on that? And so my second question is a generalized question. Anyone can answer the question. Second question is about, as Mr. Das Gupta said, that these kind of interim agreements have this tendency of staying for a prolonged period of time. Then I believe in that case, we really need to look at the paragraph 4 of Annexure 2 to the MPIA, which says that the members of the pool of arbitrators are to be selected on the basis of a consensus. And I think it will be the same issue as which arose in the appellate body, and we'll be again going to the same issue which arose in the appellate body. So what are your views on that?
First.
Yeah, thank you. No, thank you for the question. In fact, Dr. P.S. Rao partially alluded to what is the way out for the situation that you present. It is true that there are champions for or proponents, as is called in the negotiating parlance, of issues and proposals and solutions, and there are others that have concerns on what is proposed, and therefore you have to come to a compromise. And the proponent therefore doesn't always get what it began with, what was its best effort requirement to achieve its interest. This leads to actually what we have been discussing about interpretation, and Dr. Rao, I think, took that point to its logical conclusion about more work required. When these compromises happen on what proponents say, the resulting text in the treaty is constructively ambiguous. So in order to take on board all the concerns, that constructive ambiguity is introduced into the language. And as a consequence, it is subject to interpretation by dispute settlement body in the case of WTO and other similar mechanisms or pundits elsewhere. So the point is well taken, but when you have a large community of nations with a lot of disparate views on how to resolve a problem, such compromises are bound to happen. So on the larger question, maybe somebody else can.
Yeah.
Going back to the flaws that you have tried to, the point that he has raised, would you see that as a flaw?
I'm sorry, you mentioned about the selection of the...
Yes, sir. Yes, sir. It was about the arbitrator, the pool of arbitrators who will
Yes.
arbitrate the
Yes.
MPIA, any kind of dispute that arise under the MPIA. So the members who will be selected, the pool of arbitrators, it has to be selected by consensus of the members, the participating members of MPIA. That is the provision in the paragraph 4.
That's right. In fact, yes, the selection process, the Article 17.1 of the DSU and Rule 6.2 of the Working Procedures for Appellate Review, including the process of principle of rotation, they have all been adopted by the MPIA. As I mentioned, I don't have anything against the 10 arbitrators who have been chosen so far. And also, the Rule 3.2 of the working procedure for appellate review shall apply. And as far as this question which you had raised earlier about 25.4, it is true that Article 21 and 22 will apply mutatis mutandis to the arbitration award. But the main problem is, if it were to be orthodox or traditional award, arbitral award, rather than an appellate body finding of please bring your measure in conformity, how do you really have compliance? Because the DSU at the moment, or the way the appellate body and the DSB has been functioning, it is not, as Professor Zadok mentioned, and I am really thankful to him. He said it's a work in progress. We really haven't worked out the basics of how to adopt the award and make compliance, under Article 21 and retaliation under 22, a part of this whole thing. Thank you.
Okay. Yeah, Professor Sudok, and then I think Dr. Rao also wants to add something to this, so we will hear Dr. Rao as well. Yeah, Professor Sudok first.
Yeah, I think the selection process is quite similar to the DSU. So if India were to join, it's likely there would be an Indian arbitrator on that body. In terms of interference, and I'm happy that Ambassador Gupta mentioned that before, how reappointments were politicized at some point. The best protection is clearly what you proposed, which is a single long term. You want an adjudicator to have a single long term. Otherwise, the composition of the divisions and so on, basically the MPIA uses the same formula and the same mechanism that the appellate body used. So simply, instead of 7 names, 10 names are fed into the system. And maybe just to correct something what I said, it's true that the details will still have to be worked out, but that the awards are binding and that they can be subject to sanctions, that's something that the signatories to the MPIA have accepted. So practically, I know those who have read the MPIA, one of the most complex part is how do you get the case out of the panel system into the award 25 and back. But that ultimately, if there is a case between the EU and China, they would impose sanctions on each other under the MPIA is something that is accepted. But there's also, going back to the composition, there's also a benefit in rotation, and actually there will be already, I think this year, a partial replacement of the arbitrators of the MPIA, because they want to do every 2 years some replacement.
Thank you, Professor. Dr. Rao, we are just looking for your intervention.
Thank you very much for allowing me a minute again. But I think the selection of arbitrators in a given case is always a matter for some of sensitivity, whereas the arbitration provides for each party to nominate one of its own choices as members. They can nominate their own member. Generally, I'm not talking about the WTO system specifically, because I'm thinking more of the investment agreements, which have been a great subject of controversy in terms of who the arbitrators are, why one arbitrator is in 100 cases and another arbitrator rarely comes into the picture. And the same views that they have been holding for one case after another, they are trying to bring them as precedents, as it were, even though there is no such thing as precedent in arbitration system. Whether it's a maritime boundary dispute settlement, whether it is investment dispute settlement under the ICSID, etc., the question of impartiality and the suitability of a particular arbitrator to a dispute is always a matter for some concern these days. And with WTO, of course, is different because they are appellate body members are chosen and elected, and of course they are there for a term. And during that term, of course, there are certain rules and regulations under which they would get their case law before them. So there are no fixed answers to my mind. it depends upon the individual and the body that appoints the neutral arbitrators. For example, we go to ITLAS for the appointment of neutral arbitrators in a maritime dispute, for example. We go to ICSID for getting appointment for neutral arbitrators in case of investment disputes, etc. And the institutional bias and the kind of links that the individuals have to some of these institutions do play a part that is quite evident. But I don't think by itself should be a concern for us as long as the person is competent, is objective, is impartial, and has certain commitment to rule of law by himself through his record. I think that ultimately will decide. But there is no fixed answers as to who is the best judge in a given case. So it's a problem, but I don't think we can find a textual answer for that. One has to live with experience and try to choose the best we can. Thank you.
Thank you, Dr. Rao, for that very interesting and insightful comment that you have made. Yeah, arbitration is as much as a matter of trust, and it's a extensive work in progress towards the idea of certainty and fidelity to the rule of law. Thank you so much for all this wonderful time. I'm sure as seekers and students here, all of us will return to work with more queries and more questions. Yeah. And we have one more student, one last question from there.
Thank you so much, ma'am. Thank you for the meaningful discussions. My question is for Ambassador Bhatia, sir. So you mentioned the need to reform the rules, and without this reformation, the actual reformation of dispute settlement body would not be meaningful. In this background, I wish to understand the meaning of national security. We limit it to defense and military interests. Is it correct to limit it to these traditional meaning of security and not extend it to other aspects of security which are existential crises for nations, such as including climate disasters? So I wish to know your view on this. Thank you.
That actually was what Ambassador Bhatia said the panel in this motion today.
Yeah, well, I think when you're talking about climate change, the normal defense would be under Article 20, for which the rules are very well, there is a very large case law, and especially the appellate body has ruled several times on the chapeau conditions. So as far as climate change is concerned, I think the case law which is developed under Article 20 should be adequate for the moment to meet the requirements. But the problem is this. Climate change is a global concern. Now, are we content to deal with issues of violation only through an exception, which is Article 20, rather than positive rules themselves? For instance, if you look at the agreement on subsidies and countervailing measures, there was a particular Article 8 which related to non-actionable subsidies, and it could deal with issues like subsidies for environmental measures, but that was allowed to lapse. We don't have that article anymore on the statute. Now, if the WTO members could be energized to use that article as a template and to create a new provision for the times to mainstream the idea that climate change is a global concern and requires certain measures which should be permissible per se, rather than going through the exception route. I think that is what we need. Now, let me also point to certain contradictions here. Look at the issue of CBAM. The issue is a unilateral measure. And there are two comments I'd like to make here. One is what Atul was talking about, that we should allow the industry to respond to this issue. We should wait for the idea to mature. I think the industry is not waiting. If you look at, for instance, the issue of steel, which is going to be probably the biggest sector which will be affected by CBAM, India's biggest exporters are Tata Steel and Jindal. And they are already exploring various energy options like green hydrogen and so on and so forth. They're not waiting with bated breath to look at what the outcome of discussions will be in the WTO. They are already going to take steps to try to comply with CBAM requirements. So there is a certain discordance between the view that we take, that we object to it in principle, but at the same time, our industry is willing to take steps to comply with that. There is a second issue here. Now, on the one hand, we take a view that CBAM is a unilateral measure and therefore not really permissible. But there are certain rulings of the appellate body. For instance, if you look at US Shrimp 21.5 Malaysia, there are certain circumstances in which unilateral measures can be permissible. So are we going to depend on these kind of stray observations of the appellate body, or do we need some centralized mainstream rules? And that brings you to the issue of the Paris Agreement. The Paris Agreement has two central issues which are of relevance to us. Number one, nationally determined contributions. And the entire idea of CBDR. Now, we need to have a broader view of the interconnection between international agreements. How can we bring this idea of nationally determined contributions and CBDR from the Paris Agreement into WTO obligations? And for that, you need a conversation. Now, you cannot say that I don't want a conversation in the WTO, but at the same time, the trade law provision should be amended, should be viewed from the perspective of my commitments to the Paris Agreement. So I think in international law, there is a general presumption of non-conflict. That various international law provisions from various international law jurisdictions can be interpreted harmoniously. I think we need to do that exercise to look at various international law commitments in a harmonious manner, not only through the silo of trade law. And I think Atul was referring also to the issue of the pandemic treaty, which is being negotiated in the WHO. And I think it's a major gain from the pandemic, the COVID pandemic that happened a few years back. But we need to also mainstream the obligations and commitments in the pandemic treaty in the WHO to the WTO. The WTO law cannot be interpreted as an island, independent of the commitments which are being made in related agreements like the pandemics treaty. So broadly, what I'm saying is we need to take a much larger view of international law and not look at it only from one silo of trade law.
Thank you, Ambassador Bhatia, and thank you for all the panelists and the audience for contributing their time and also their presence to making this particular panel very interesting and much insightful. And I'm sure we will carry many of these insights back for our further studies here. Right? I have a small request to the organizers. Oh, Dr. Rao has left. Okay. So I was hoping that if Dr. Rao is here and we can have a picture with him in the background with the video on, because I have promised that picture to Professor Venkat Rao at the Law University in Goa, and he wanted it. So if it is possible, yeah, I think he's got him. Can I request the panel for a few moments more, please?
I have a few announcements to make. The lunch is ready in the convention center. The panel, the next technical session will begin at 2 a.m. sharp in classrooms number 1, 2, 3, and 4. 2 p.m. At 2 p.m. All the participants are requested to have their lunch in the convention center lawn and not in the dining hall. The dining hall is reserved for the organizing committee and the panelists. And everybody is requested to be in the panel session, in their technical session rooms by 1:50.